Yes.
Adjournment request, if any, right, from item number 1 to 6. From item number 7 to 18, adjournment request.
14.
My lord, in item 13, 14, and 15, we had circulated a slip.
All right.
Public.
Lordship, may I just pray for a date, Lordship? There was to obtain instruction, Your Lordship.
What date? Give the date.
26 February.
Lordship. Abba.
Yes.
From item number 19 to 24, adjournment request.
Please, Your Lordship. Lordship, I beg to mention item number 22. Lordship, it may be adjourned for the day, Lordship.
For the day. You want to pass over for the day?
Lordship.
Yes, Lordship.
All right. Pass over for the day.
Your Lordship, I'm praying for a date to be fixed. Your Lord.
Pass over for the day means it comes tomorrow.
Lordship, he has some difficulty. I think.
Lordship,
Make a prayer. You want a 1 week time, 2 weeks time.
The second week of
second week of
Pass
February.
it over. It comes tomorrow.
second week of February.
Second week of February, Lordship. Any day, second week of February, Lordship.
As jointly prayed for. Re-notify on. Give it time. Sometimes in late February.
Late.
All right. Yes.
God bless you.
24. Any other request?
Yes.
Sorry to trouble one matter before this court. Well, there is one matter related to APSC,
Yes.
where Honorable Justice Chaudhary will not be able, because last time we also.
Is
the
it
matter
listed
we
here?
decided- No, it's not been listed.
Yes.
Now the difficulty is that the special division bench has been constituted by your lordship, but that too also Honorable Justice Chaudhary is not taking any matter related to APSC. Only remains, there is one bench, division bench too. It's up to your lordship. Your lordship can list any other bench constituted, or my lord, there is only one bench left.
Just give a slip.
Already
slip of
yesterday,
Hmm.
yesterday we have written to the Registrar General. Already we have addressed.
All right.
Before coming to the court, I said, you please address a letter to the Registrar General.
Ask
according
the
to-
RG to bring that letter to me. I'll constitute a bench today.
Yes, I am deeply sorry for troubling.
No,
because
it's
this-
taken up already to other matters.
Mm.
I'll constitute.
Because
it
one,
today.
I think one matter, when it came, it has been, your lordship has sent back to division bench too, because there was only one bench. It is up to the court. Your lordship can constitute any bench, no problem for me.
APSC matter. We'll see. Let me do it now.
Yes.
Yes. Any other matter?
May I please, Lordship? Lordship, pair for listing a contempt petition, Lordship. In this matter, Lordship, the petitioner is a auction purchaser, Lordship. He thereafter the property had not handed over to him.
No fact. Is there any direction by the court?
Yes, Lordship.
And that direction was time bound.
Yes, Lordship. 4 weeks here.
4 weeks.
And that is
Nothing has happened.
Nothing happened.
Yes. After 28. 27th or 28th?
38.
No.
30th January.
Okay.
Daily list for orders item 1.
Yeah.
Respondent number take is not.
Yes.
May please, Your Lordship. Services completed.
Why has it come for orders?
My lord, the service with regard to respondent number 6 has been affected, my lord. We filed the dusty affidavit as well, my lord. So services
Whom are you appearing for?
I am able for the private respondent, my lord.
one, respondent
No,
one.
it is-
Respondent
Written
one.
petition.
Who appears? Wait, let us wait for respondent number 6. You have served him.
Sir, my lord, the
He was the
affidavit is on
petition-
record.
He was the writ petitioner.
No, respondent number 1 was the writ petition.
Respondent number 6 is not the writ.
No, he was one of the parties in the writ petition.
All right. Awaiting the
Here,
appearance.
my lord, there is an interim order, my lord, on 16/5/2024.
Hmm.
Your lordship is directed for regular appointment of the principal in the school. Now, my lord, it is more than a year. They have not acted on that. So BTC, Board and Territorial Council, none is there.
Okay.
Formal part.
Okay. And way back in the month of June, service
Just a
has been
minute, can
effected.
anybody inform the school management committee that we are to take up the matter? Standing Council, Education? Mr. Katniar, you represent. Anyway, awaiting the appearance of respondent number 6 in the matter. This case is adjourned to again 30th of January.
Deeply obliged.
Item 2 and 3.
Okay.
Lordship, I appear for the appellant in item number 3, Lordship. In this matter, earlier Mr. B.C. Das Senior Counsel was there, Lordship, but subsequently he could not come to this. Won't be able to come, Lordship. There were talks with the authorities regarding engagement of another senior advocate, Lordship, but then that senior advocate also declined. So now
Who appears in item number 2?
Two, I am appearing, my lord. After the interim order was passed, 2 years time has gone like this, my lord, adjournment and adjournment, my lord. The
No,
only thing is that, my lord,
you find out some lawyer or you address us.
my lord.
Lordship,
We give you 1 week's time, get ready.
Lordship.
All right.
Admission column, my lord.
Since the service is complete, let both the matters be listed under the appropriate heading of admission on first week of February.
I'm obliged, Lordship.
12th February. 12th February. Item 4.
Service is complete, I suppose?
Service is complete. He has also appeared, your lordship. Your lordship has fixed today for disposal, your lord,
For disposal.
for disposal. May kindly go to the last order. 9. I have to dispose
Who
of.
appears for respondent number 6 here?
Lordship, I am appearing.
Ready?
Lordship, kindly pass over the matter for a time being. My senior is on legs.
Who leads you in this matter?
Mr. H. Das.
So let you come for admission tomorrow?
Lord.
Okay, the service is complete. Let this matter come up tomorrow. Tomorrow, nahi likhna, date likhna tomorrow. Under the heading admission.
Obliged.
21. Item number 5.
Yes.
Lordship, on the last occasion, Lordship asked me what,
No, we forgot what we
yes,
asked
Lordship.
you. We have
Lordship,
forgot-
here,
Yes.
this is an appeal by repetition by Union of India, Lordship. The respondent had challenged the rejection of his representation, whereby he had sought given 5 choices for transfer. Our ground is that he had not completed the tenure of 3 years, and the previous previous transfer is as per his choice. So, as per the transfer posting policy, Lordship, whenever a person gives a choice posting, it will be treated as a P station. And there is a list, an appendix, that what is the stations and which is a tenure station and which is a P station, Lordship. So as he had given on earlier occasion a choice posting, and he had not completed his tenure for the posting for 2024, we have rejected his prayer, Lordship. Challenging that, he had filed a the application in CAT, Lordship, and that was allowed, asking to give his choice posting as per transfer policy 2024. Being agreed, this petition, Lordship.
Now let us see the order of the tribunal.
Lordship,
Page
it's 258, starts from 258.
This is the open. Clear. The respondent has, I mean, he has a service of more than 10 years or less than 10 years.
More than 10 years.
So therefore, 2 years would be the tenure.
No, Lordship, because which is for 2 years, that is in another appendix. That Lordship will find at page 40.
No, we are at page 266, the office memorandum dated 14th of December, 1983.
Here, Lordship, we have our own policy, Lordship, and as per that
Let's
policy,
come to this, no? There will be a fixed tenure of posting of 3 years at a time for officers with service of 10 years or less, and of 2 years at the time for officers with more than 10 years of service. Period of leave, training, etc. That's something different. Which OM are you talking about?
page 30, Lordship,
Page?
30.
30.
30.
Yes. Yes.
As per this,
This
Lordship,
is dated.
this is dated 7 June 21.
What does it say?
Lordship, here is a at page 43, Lordship, page some stations, which is a complete stations, and page 46 are those stations for which
That we
the
have understood. We'll look at that list sometimes later, but tell us the principle on which you effect transfers, especially on demand.
Lordship, this list is important. Why, Lordship? This
List we have followed. There would be peace stations, there would be tenure stations.
no, Lordship, for 2 years there is a separate stations at page 47. For those stations only, this is for 2 years, and for other stations, page 46, this is for 3 years, and it is in the list also. At page 46, list of tenure station having 2 years tenure is listed as appendix C. So appendix C is page 47. List of tenure station having 2 years for turnover.
Now this Annex D dated 7th of June 2021.
Lordship,
These are posting or transfer policy of GPB non-gazetted. Non-gazetted.
Lordship,
The respondent is not non-gazetted, no? These are the policies that I had asked you to check up. You know, there is 1983 policy which talks of 3 years. Correct.
Lordship,
Now you are showing to us your own policy of transfer, which the policy came in existence on 7th of June 2021. But as I can see the rubric, it's for non-gazetted employees
Lordship.
and GPC employees. What is GPC? Are they gazetted?
So Lordship, my instruction is that after considering that 83 and 98 policy, this policy has been framed.
No, I'm asking you something different. I don't know whether you are appreciating what we want to know from you. Normally, we would not interfere with transfer and we would not allow the tribunal also to do that. Your case becomes very strong, especially when he has asked for tenure to peace before he completes his term. His term would come, the cycle would come in 25, he wanted it in 24.
20.
Now 2 years have passed by. Now this is 26. What is the present status?
Present status, Lordship, he is eligible for transfer, but not as per his choice, because in the previous occasion,
No,
he
you
was-
asked for choices even for peace stations, no?
Lordship. Now he had given, on the last occasion, he had given 5 choice posting and all are peace station. And as per this policy, when one is posted at peace station, although it's a tenure, but as per his choice,
Because he made a choice, therefore
Yes,
it is treated as
it
peace.
is a peace. So now he is not eligible for any choices. He is eligible for transfer.
He is eligible for his transfer is imminent, but he is eligible for choices of tenure post.
Or as per the convenience of the authorities. They will definitely see, not as, he cannot have any choice.
But this policy that you're talking about, which you argued before the tribunal, this is with respect to non-gazetted.
Lordship.
And 1983 policy is with respect to the gazetted employees.
For the
That does not make any distinction. It says employees of the central government service in the state and the union territories of northeastern region. That's the only thing, no? Now 3 years have passed by. Yeah, what is your stand? What do you want now?
This issue is already settled by this honorable coordinate bench of the honorable court. Already settled. The same issue. Because Northeast policy they have enclosed that judgment. Their judgment they have enclosed.
Mr. Chanda, we don't understand this argument. Already settled. Where is that settled order?
The 206. 206 of the writ petition. Same issue involved. And general policy of the government of India prevails over the internal policy.
206.
206 para 2, 12 and 13. 206 is started, my lord, and 206 is started para 2 page 207 and then para 12 and 13. 212 and 213.
Paragraph 12.
12 and 13.
Where, what issue has been decided there? You say it is the same issue. I don't think it's the same issue.
No, not
My lord,
same.
1412/83 is the general policy of the government of India, which these are the circulars she has shown. Even I am covered by their
We have
circulars.
followed.
Even I am covered by their circulars.
Mr. Chanda, that is 1983 has been issued by the finance department.
Finance dependent for all the departments
That's right.
of the
That's
government
right.
of India.
But then your service,
Ah.
there are specific rules of transfer. This policy was effected in 2021, 7th of June, 2021.
This is my lord, in my humble submission, this is internal policy. Even I am covered by their internal policy also. I am covered. And this is a general policy of Northeast. This is, my lord, incorporated in the fundamental rule. In the fundamental rule, page appendix 9, my lord. Fundamental rules, the appendix 9, my lord. I'm giving this book, my fundamental right 14, 18, 12, all civilian. I am a civilian employee, non-gazetted civilian employee, my lord. I am a non-gazetted civilian employee. And clause 18, your lordship, there clause 18, page of the transfer policy, page 33, your lordship. In my, it is started from page 28. They are 7 June 2021. 7 June 2021, clause 18. Relevant page is 33. Lordship got it. Page 18, page 33, my lord. It is started from page 28. Annexure D.
17 and 18.
Para 18. A tenure station will not be treated as peace station for any employee whose hometown selected piece of residence in the radius of approximate 100 kilometers of that complex. Remaining all other declared tenure station will be station for them. Likewise, peace station within 100 kilometers from home station selected place of residence shall be treated as a peace station. I am now posted in a 400-kilometer away from my
Now, read
Residence.
17 and 18
Yes.
together. Read 17
yes,
first.
yes, my lord. And this has been superseded. New policy has come before my joining. New policy is, my lord, page. This has been superseded. Page 162, 28/4/2022.
That is subsequent, lordship.
Yes, I am covered by that
No,
subsequent
lordship.
because I have joined on 22/7, my lord.
Okay.
Page, my lord, 162. 162.
Guidelines, management of.
April 22.
Which provision?
Provision, my lord.
Which provision?
Page 165 in the bottom,
Hmm.
Roman 6.
Hmm.
The normal period of tenure at a station complex notified by Government of India and hard station notified by Government of India and hard station complexes designed by ENC's branch, CE command, will be 33 months physical stay for the individual with service of 10 years or less and 22 months for those with service of more than 10 years. And for HAA, 22 months, irrespective of length of service, date of posting should be the reference date for deciding less than 10 years of service of otherwise. So, my lord, 22 months in my case that I have crossed long back. Now I'm 3 years and half, 3.5 months, 3 years half month. So this is the new policy,
This is,
and that has come on 28 April 2022, prior to my joining in any region.
but it was done in February 22. The TTP
This is
22
their
was
policy,
done
my
in
lord.
February
It is their
2020.
policy.
Subsequently, it is from April 28, April 22, but the transfer which he was posted at Rangya, that is of February 2022. So he is not covered by this policy.
July 22, I have
This
joined.
is a- this one.
And these are internal policies of the department. And general policy of the Ministry of Finance, it, my lord, it suggested to follow all the ministries and departments. That is page.
Now, just a minute. Your peace to tenure posting in 2022 was at Rangya. That was a tenure posting. And you had given your choice. So
My-
that choice is not important here. 2022, you were posted in Rangia, which was a tenure post. So you say that you are required to be there for 2 years only, and then you earn the chance of coming to a peace posting.
My choice station. Choice station as per 14/12/83. It is, my lord, this is internal policy. I am also covered by the internal policy and 14/12/83. 14/12/83 is page
So
263.
Just a minute. So what happened after your request was turned down?
They have rejected it.
What happened thereafter?
Thereafter.
You're still posted at
Yes.
Rangia.
I am still working.
So now forget about all these wrangles and policies. Now you have to go back to your
Choice
peace
station.
posting.
Choice station.
No, because Rangia is peace. He had given choice,
No. This was peace to tenure in 2022.
but he had choice when this as per
Whether choice or no choice. Well, suppose difficult step. In his peace posting, he seeks a choice for tenure posting. That will be considered to be peace.
he had
Exactly.
given 3 choices in 2022. Out of that, two are peace station and one Rangia is a tenure station.
Mm.
But he had chosen Rangia, which is a tenure. But he had given Siliguri and Kolkata, they are peace station. But instead of going there, he chooses Rangia, which is actually a tenure station as per appendix. But as he given a choice, it will be treated as peace.
Suppose in 2019, he would have chosen a tenure posting, that would have been treated, that could be treated as a peace posting because that was his peace travel.
But as per
In 2022, he was to move from peace station to tenure station. Correct?
no, that he has to
You
there.
make a chart first.
No, I have.
So you have not. Every time you say you have, but you have not. Now, please look at this. Unnecessary, please don't confuse facts. In the year 2016, he was transferred from peace station of Siliguri to Mizamari. This was tenure. All right. Then after 3 years, from Mizamari, he goes to Gantok. This was his option of choosing a peace station, but he chose Gantok. Gantok otherwise is in the list of, tenure posting, but that was treated as peace. And from 19, he had to come to tenure posting in 2022. In tenure posting, he chose Rangia, which is his choice, no doubt, but it is a tenure posting. Correct?
Posting is tenure, but as per clause,
Choice makes it peace only choice makes it peace if from tenure to peace he's traveling and he indicates that no, I shall remain at tenure station only. I will not have a peace station. Because of that choice, that station would be treated to be a peace station. And then he comes back to tenure again. So it would be a tenure to tenure, but because of that deeming understanding that now since he has chosen a tenure station for his peace entitlement, then that is also peace. So from peace to tenure, in 2022, he goes to Rangia. Rangia otherwise also is a tenure posting. So either in 2024, according to him, by the rules that he says that 22 months after 10 years of service, he can have a transfer. He wanted it in 2024. You said, the government said, the employer said that no, his turn would come only in 2025.
No.
Now we are in 2026.
We are in.
Now, therefore, he has to go to a peace posting. Because Rangia, do you dispute that Rangia is a tenure posting? Forget about all these 1983.
yes, officially Rangia is a tenure posting in the list of tenure.
You have not been able to understand what we are asking you to do. Normally, we would not have allowed Mr. Chanda's claim. Had it been only 2024, we would have gone into a different reasoning. Correct? Now that period is over, he still remains posted at Rangia. Now he has to go to a peace station, no?
And 2025, he become eligible as per the authorities.
So now it is 26.
Yes.
Forget about all things are of the past. Now what do you have to say? This is what I had asked.
And they
you
have,
about.
my lord, filed a miscellaneous application before the tribunal that they are complying with the order. And again, they have filed the 3 petition. These are the
That we don't bother for all that. They have a right to file a petition as you have a right to. Those, she should not have made that promise. But now what do you have to say? In the year 2026, he can't be tied to Rangia only now. He has to be given a peace tenure. Now, we will not look into other aspects of the matter. We will decide it like this. Now, you can't raise an objection with respect to 3 years or 2 years.
Lordship.
More than 2 years,
Yes,
more than
yes.
3 years have
That
passed.
is over.
That's over.
That's over.
Rangia is a difficult station, tenure station.
It's a tenure station.
Even though it was his choice, but it was a tenure. And that choice was exercised in his tenure entitlement.
Lordship.
So therefore, you can't make it a peace station. A tenure station could be considered to be a peace station if during his peace entitlement, he goes for a tenure posting. Not otherwise, not vice versa. Correct. So now with him having served for more than 3 years at Rangia, he has to be transferred to a peace tenure, to a peace posting. And peace posting, you give him a choice. Now, no memorandum, no circular comes in your way. 3 years have passed by.
Lordship. He is eligible for transfer now.
Take a call, say this, withdraw this petition, post him. You'll be saved of the trouble of going to the tribunal and saying that the order has been complied with. You say that you challenge that decision on merits till the time he had not completed 3 years. Now that he has completed 3 years, the natural course of the policy decision will take place.
No.
If this case would have been argued in 2024 or even in early 2025, we would have thought in a different way. Now it is 2026, therefore we have to take a different call, a reasonable call. Whether it is his entitlement or no entitlement. After 3 years, you'll transfer him. Normally, especially in Northeast, and he has crossed 10 years of service.
Lordship.
And he has he has served at a tenure posting for more than 3 years. Transfer him to a peace posting, give him his choice. Where is the difficulty?
But only thing is that he had given recommendations by 2024. That recommendation is a bit difficult because we have to.
Everything vanishes, it goes in the background.
Lordship.
Now, with he having served in the peace station for more than 3 years, he deserves a posting in peace.
As part of vacancy in the peace station.
You can't place him where there is no vacancy. So amongst the vacant positions, you take his choice, post him. He is not going to he can't claim that he will be posted at a particular place where there is already an officer.
No,
He
but
can't be elbowed out.
the only difficulty is that he may give 2-3 places of
In
places.
addition,
but-
they have other person, those who are not having any preference.
Chanda, can you hold back for a minute?
Mile.
So what I want to submit, Lordship, that there may be 10 vacancy in peace station and any of the peace station. He may give his choices, but authority has to look after that peace station. Maybe as
Out of the 3 choices, give him. Out of the 3 choices. That's your policy. You have been doing it in the past. You can't keep on fighting like this with your employee.
Lordship may pass the order.
We have heard. Where is the? We have heard MSB Sharma for the petitioner / Union of India and Mr. M. Chanda for respondent number.
Sole respondent.
For the sole respondent. This writ petition has been filed by the Union of India challenging the order dated 8th of August 2025 passed by the Central Administrative Tribunal, CAT Guwahati Bench, in OA number 4040/211/2024. The respondent is an assistant accounts officer with the military engineering service, the whole dispute between him and his employer is with respect to his posting and transfer requests under the government's posting/transfer policies for civil employees in the northeastern region, particularly involving the concepts of tenure stations and peace stations. Next, the respondent was previously posted from Siliguri to Mizamari sometimes in the year 2016 as a transfer from peace to tenure station. After 3 years, with his entitlement to be posted at a peace station, he was transferred to Gangtok in 2019 on his choice, notwithstanding the fact that Gangtok is a tenure station. However, since the respondent had chosen this station to be transferred, it was considered to be a peace station. His turn to be transferred came again in the year 2022 when he was required to be posted on the posted at a tenure station. Out of the 3 choices that the respondent had given, he was posted at Rangia, which is actually a tenure station. Under normal circumstances, his stay at a tenure station would have been over by 2025. When he was required to be returned to a peace station. However, before that, in the year 2024, with reference to a policy decision with respect to transfer, he sought a transfer to the peace station, claiming that he had crossed 10 years of service and the policy required a maximum of 2 years of stay at a tenure place, at a tenure post. The department resisted and took the stand that the transfer term of the respondent would only mature in the year 2025. The representation preferred by the respondent was rejected. By a speaking order, which was challenged by him before the tribunal. The tribunal, after having recorded the submissions made on behalf of the parties and referring to the OM's, referring to the Government of India OM dated 14/12/1983, as well as the OM dated 22/7/1998 opined that the respondent was entitled for his choice transfer at a peace station even before his tenure, even before his stint at the tenure station would have normally ended in the year 2025. This factual aspect could be debatable to the extent that there are Government of India OMs issued by the Finance Department, which would apply to all other departments, and a specific transfer policy of the Military Engineering Department, which are not even mutatis mutandis similar. Be that as it may, presently the dispute does not remain a list to be decided for the reason that the respondent has remained posted, partly because of the litigation at Rangia from 2022 to 2025, which is a tenure posting. Stop. Without making any animadversion at the application of the tribunal of the concerned OM regarding transfer, we are of the view that with the respondent having completed 3 years stint at the tenure posting, at the tenure 3 years stint as at the tenure station, anyways, he is entitled for a transfer to a peace station. In fact, the respondent has stayed at the tenure station for more than 3 years by now. In that view of the matter, we direct that, in that view of the matter, but with a different reasoning, we direct that the order of the tribunal be complied with and the respondent be given a choice posting in any one of the peace stations which is vacant. We further make it clear that the respondent would not be entitled to insist for any particular posting, but only for giving his choices amongst the vacant peace stations where he shall be transferred, preferably within the choices subject to the availability, subject to the vacancy. With the aforementioned clarification of the tribunal's judgment, the writ petition stands disposed of. Where is the difficulty? Why get into all this OM of 83 and 85?
The only thing is that, Lordship, now it will be TTP 2026. 2025 is over.
That's over. That's a no man's zone. That's a what's that period? That is a which period we don't know. So he goes for 3 years.
Lordship, and that may be
Why
2026.
should we do that? We are not going to handhold you every time. You take a call. You have decided. You have put it. You should have passed an order unless there was a stay. This was only for. See, you saw red herrings only when he wanted a transfer in 2024.
No.
Had he asked for a transfer in 2025, you would have willingly given. So now 24, 25, those years have passed by. Why get into all this wrangle? I don't understand. You have to behave like a model employer and he has to behave like a good employee. He can't insist that he will only go to Gantok or someplace. It's a peace station. He gives his 3 choices. If it is vacant, give him. If not, throw him at any other place. We can't help it. All right.
Diplomat. Diplomat.
Item number 6.
May I please, my lords?
Order.
Lords, in item number 6, the government had sought time to file reply affidavit.
Yeah.
of
Yes,
class-
Mr. Khatniar.
I'm praying for some more time to file our response.
How many more weeks would you require?
Only 2 weeks, my lord.
Only 2 weeks.
Yes, my
What happens to the appellant? Appellant
appellant.
is online.
Appellants, my lord.
Yes.
Lords, they're asking for time. In all fairness, I should not.
Can you
oppose-
hear us, Mr. Counsel for the
Yes,
appellant?
yes, my lord, I can hear. Am I audible, my lords? Can my lords have-
You have muted yourself. You need to unmute if you can hear us.
Yes, I can hear, my lords. Can my lords hear me?
This is
Can my lords hear me? I am able
just
to hear, my lord.
do something about volume.
Can my lords hear me now?
Hmm? This is the max. He has his problem. Do you have any local advocate standing here in the court? Please call him and tell him that he is not audible, number one. The problem is on his side. And number two, the other side, Mr. Khatniar wants some time. So we are adjourning the matter for 1 week only, Mr. Khatniar.
Can my lords hear me
You've
now?
already taken time. Have you filed your affidavit?
No, my lord, no. I'm,
Why?
this is for the second time, my lord. This is listed for the second time.
So first time, so you have, as a right, you have
No, my lord,
you have
I'm-
3 chances at general.
No, my lord, but
Just-
I need only 2 weeks time, my lord.
Have you received instructions?
That is, my lord, that is what I'm awaiting, my lord.
Now,
That is why-
see, you're unnecessarily delaying it. The appointment process is over now.
Yes, it is over.
But then they have a right which they can't be stopped from, vindicate, get their rights vindicated.
Yes, my lord. Only 2 weeks, my lord.
They did not file if I remember correctly, on the last occasion we had seen that they could not furnish the, what is that?
B.Ed certificate, my lord.
B.Ed certificate within time.
Yes, my lord.
But that was not their fault. It was because of the university. And you had midway, you had removed that clause from the advertisement,
Yes, regarding relaxation.
giving them the entitlement of relaxation. Could you have done that?
I'm so grateful, my lords. I'm so
Now,
grateful.
that's the question which you're required to answer. I don't know,
Only
he's
2
not hearing. Anyway, Mr.
I-
Counsel, if
I
you
can hear,
can,
my lords.
we can't hear you.
My lords, I'll reconnect. Just give me a minute. I'll reconnect.
He's gesticulating, but we can't understand.
Lordship, if grant time for 2 weeks, Lordship, in the meantime, Lordship, my humble submission, your Lordship.
Reserving certain seats. No, we can't.
Only
No, we
15
can
seats,
give you an early hearing. We don't do that. Within 10 days, file
Yes,
affidavit.
my lord.
As a matter of last indulgence.
Yes, my lord.
The matter is adjourned at the instance of Mr. Khatniar, who has yet not filed his affidavit. So stop. Let this matter come up for consideration on the 11th day, whichever date it falls on. Tell him on telephone
Yes, Lordship.
that this is what has happened. I wish I was good at dumb charade. Yes.
5th February, 5/2.
Obliged.
Obliged, lordship.
Can my lords hear me now? I'm so sorry.
Yeah, what is the problem? I don't think the problem is from their side.
Lord, hear me now?
Can you hear us?
Yes, my lords, I can hear. I can hear, my
But
lords. I can hear.
think we have some problem in the But we have adjourned the matter for the next date, and no further adjournment we have indicated.
So grateful. So grateful.
Obliged, lordship.
Item number 7.
appears for the state? Respondent. Mr. R.P. Chaudhary, he was here?
No, no, health department, Sunny Council Health.
No, no, this is Union of India. Who has
Item
to pay?
7.
Item 7.
Item 7, my lord.
Union also.
Who is the paid?
TD Bora, my lord.
BP
And there are also appear, my lord.
Where is Ms. Bora?
Number of time he was appearing.
So we appreciate a very harsh view was taken by the learned single judge. Now we can't possibly proceed in contempt. These are health workers, 3,000 rupees net salary. That also is not being paid. Where is Ms. Bora?
Not Mr. This is BP Bora or Saliha or Mr. Gogoi.
Finance.
Do you know any one of these advocates which my brother?
Yes, I know some, Lord, I know.
Go and tell them that the court is wanting their presence. We'll hear it again. Let's see what we can do. Technically, we do not, we cannot find fault with the order passed by the single judge, but we are paying at the very fact that these health workers are not even being paid their stipend or minimum, not even minimum wages.
900 money.
And then their claim has been rejected because it's an old one. Difficult. Now we'll try and get something for you all, but not basically on merits. We'll see what can be done. So we will post it next week. Just inform any one of the lawyers.
Yes, sir.
Who will be the
Mr. DP Bora.
DP Bora is.
inform Mr. DP Bora.
Yes,
And also I'll Saliha P. Nayak.
Oh.
Do one thing. You inform Mr. P. Nayak.
Yes.
Look here, the counsel for the appellant is present. Appellant, no? The counsel for the appellant is present. There is no appearance on behalf. Chodo. Let this matter come up for consideration on next week. But we can
29.
say that nobody on behalf is, the counsel for the appellant is present.
Who is junior? Mr. Gogoi is the.
Mr. Gogoi, just look at this file. You may not be directly involved, but you are additional advocate general. Ah. Whether or not, but just look at this. These are health workers.
My lord.
Their claims are pending since 1980. They entered the service sometimes in the year 1986. Some were appointed in 1989.
My lord.
Series of litigation till Supreme Court. They were first getting 50 rupees as per month as their salary, which is cruel,
Lord, sir.
which was increased to 3,000.
Lord.
There have been arrears in payment of that also. And the single judge, for good reasons, though for not very plausible reasons for us, but
My
for
lord.
good reasons legally, he says that it's an old claim, we are not executing courts.
My lord.
But can you do this to class 3, class 4 employees? That's my question.
My lord,
That's our concern. Can you do that? And they are not even asking for upgrade.
my lord.
Whatever was due to them, which you have not paid, check up from the records, give it to them. Otherwise, if you want, we'll say that the reasoning given by the single judge is incorrect. It's a continuing, damage to them. And therefore, it's your duty as an employer. You're a benevolent state. You're not a despotic state, are you?
No, Lordship will keep it pending, my lord. Let me have the status of
Therefore, I
inspection.
said, I'm not asking for a concession today. You please look into it.
In fact, my lord, they are verifying, my lord. Some has been paid. Some amount has been paid to some of the.
We would be very happy to hear that. You just find out and tell us what can be done.
My lord.
All right. The arrears of the salary of health workers is pending for a long time. The learned single judge did not entertain the writ petition on their behalf on grounds that earlier also orders were passed which could not be executed, and there has been an inordinate delay in pursuing in the appellants pursuing their cause. None of these reasons convince us. In the wake of the health workers not having been paid for years, the health workers not having been paid their meager salary, which for many years remained lesser than the minimum wages, for years. What did I say? I will complete. We have requested Mr. B. Gogoi. This bench has requested Mr. B. Gogoi. B. Gogoi. Mr. B. Gogoi, Learned Additional Advocate General, to look into this matter and assess this point. Let the name of Mr. B. Gogoi be reflected in the cause list henceforth. Date. Give him 2 weeks. You find out and tell us.
12 February.
You want 1 week more, we are agreeable to it. After 3 weeks. But please see that don't be so rigid about it. They're not asking for anything more. They're not asking for any upgrade or something. That claim they have abandoned.
Series of contempt cases, my lord. All the contemners have been paid for these projects.
This is again very bad.
I will have the instruction.
18 February. Hello. Item number 8.
Well, as the Supreme Court decided about second pen.
No, Lordship, this matter in fact was to be listed today for the Honorable Supreme Court. I am not aware whether it is there before.
In view of the fact that, well, we'll not say it has not been decided.
Let it be after 3 weeks, Lordship, in the meantime.
No, we are only saying for what reason. The reason we don't want to spell out, no? Let this matter, I say, for the reason of the pendency of similar issue before the Supreme Court of India in Union of India and others versus Balkrishna Bullikate, bracket SLP number 27725 of 2024. The matter is adjourned to give a date in March end.
March 23rd March. Item number 9.
Mr. Nath, last time you had given us this executive order.
That yes, I have given him.
But this is not going to help, no? You must come out with a rule.
Yes.
So that they will do, my lord. But for the time being, since there is nothing, Lordship has passed an order, and for the time being, my lord, this will hold the field. Not they will follow.
Show us where is the procedure delineated?
Lordship, number one, my lord, they have taken a decision that.
Have you gone through?
Yes, I have given.
I think this solves the issue for the time.
My lord, my humble submission is that pursuant to this executive order, my lord, direction may be given the case of the petitioner as well as the respondent one may be considered in the light of.
That is then decision on merit. So we have not seen what is the issue.
Yes.
Let's see.
In the present case also, my lord, more or less same procedure has been followed in appointing the present appellant, my lord.
Now you have to tell us whether the decision making of the authorities in granting that license, that was in consonance with this executive instruction. You find out and tell us. If not, then we send it back again. You find out and tell us, then we'll send it back again.
Yes.
When will you do it?
My lord, after one.
Give him a copy of that executive order.
I've given. It is with you.
You should have come prepared on that, no?
Yes, ma'am.
You should have come prepared. I say, I mean, today only we could have done that.
Yes.
You can do that today.
आज करेंगे? Would you do it today?
Yes, ma'am. Can be done, my lord.
It can be done. तो बताइए.
Yes. My lord, here in this case, my lord, the executive order clearly says that the applicant should be filed.
Let us see the decision.
My lord, the impugned order is at page 104, my lord. And the relevant portion Is that page 109? It start. Paragraph 7.
One second, give us 1 minute, we'll do it again. Nelson got that. This LPA. huh? Is this LPA? Huh. Please, Kuldeep Kumar Mishra. Krishna Baladhi. No, we possibly can. Who appears for respondent, private respondent? You ready? Okay. एक सेकंड रिमांड किया है But why did you challenge it? Look here. The grant of license under the fair price system, under the grant of, what is that? Fair price shop license. The grant of fair price shop. No. The grant of license under the fair price shop system to the appellant was set aside by the impugned order, by the impugned judgment dated 16/5/2024. And the matter has been remanded to the authorities to decide afresh. During the course of arguments, it was found that there was no procedure prescribed under the Assam Public Distribution of Articles Order 1982 for grant of licenses, which could have otherwise led to arbitrary decisions by the authorities. Come on, this court inquired whether any rule exists with respect to grant of license. Mr. D. Nath, learned advocate for the state, learned senior standing counsel submits that formulation of rule is underway, but in the interregnum, an executive order dated 19th of December 2025 has been issued delineating the process by which licenses under the FPS is to be granted. Stop. In that view of the matter, we do not wish to interfere with the impugned judgment of remand to the authorities. But we only clarify that the authorities in question shall fairly decide as to who should be given the license, which decision shall be in accord with the executive order referred to above, dated 19th of December 2025. The decision in that regard must be taken, if not already taken, within a further period of 3 weeks, within a further period of 4 weeks. By a speaking order. The appeal stands disposed of.
That decision may be taken in between the respondent and the appellant. my lord.
No.
Others also, rest, whatever.
Item number 10.
Much of-
Yes.
May please, your lordship, my lord, the authorities filed a affidavit in opposition, lordship, wherein they have stated that after filing of this PIL, lordship, the work already started, lordship. And that as per statement, lordship, that would be completed by 10/3/2026, lordship,
10/3/2026.
26, lordship.
Hardly 1 month,
Yes, lordship. So
hardly 2 months to go.
hardly
Not
2
even
months.
2 months.
Yes, lordship. Although works
Let's
resumed,
see,
lordship.
Mr. Nath keeps up his promise.
Lordship.
Again. Dispose. Then we dispose it on.
Maybe, lordship. But my lord, I am afraid, lordship, that after disposing, lordship, if they again stop the work, lordship, because after
No, the
intervention of this,
Petitions pending like this. We can't.
time,
yes, lord.
time has been extended till
See,
10th of March.
Our job is only to ensure that
Yes.
things are done in proper manner, but we are not running the show. now.
Yes, yes.
Therefore, you can always file a petition, say that they made a false promise before the court, they obtained an order, this petition was disposed of. We have heard Mr. NH Barbuyan, learned advocate for the petitioner, and Mr. Dina, standing counsel for the PWD department. An NIT dated 3/1/2024, inviting bids for construction of several roads in Assam, including in the Kachar district, was issued. Respondent number 6 was selected as the concessionaire for execution of 5 works in Kachar within a period of 12 months. One of such works was construction of a road from Katigora Harinagar (KH) at Cheragi Bazar to Jagdishpur Point 5. Next, a detailed project report was prepared, incorporating estimated expenditure, including the cost of earthwork. Next pack. Though the work was commenced by the contractor, but he chose to begin from the end point instead of the starting point of the road on the plea that there is an irrigation canal at the starting point, and that it would require humongous efforts and cost at earth filling. As a result of such procedure adopted by the contractor, the road still remains unconnected between point to point. The objection by the contractor has been contested, and it has been argued that the starting point of the road in question actually falls on Patta land. This fact also has been disputed. And it is projected that perhaps the land from where the road has to start belongs to the irrigation department. This fact appears to be correct, as the executive engineer Barkola and Katigora, bracket irrigation, by his letter dated 17/3/2025, has granted no objection certificate for the road construction in public interest. Till the time of the filing of the petition, only 36% of the work had been completed. The affidavit filed on behalf of the respondents on
7th of January.
On 7th of January 2025, however, indicates
26.
the 7th of January 2026, however, indicates that the
Para 5.
construction work is going on, and in every likelihood,
Para 5 last part.
and in every likelihood, the work would be completed before 10/3/2026, which is the time limit given to the contractor.
Gotcha.
Considering this stand of the state, we do not wish to continue with this petition any further, but with the liberty to the petitioner to approach this court again with a 2 pages affidavit for reviving this case in the event of the road not being constructed by that time. This PIL stands disposed of.
Item 11.
May it please.
We have passed some order. Let us go through that order case. It's only for the ease of business, Mr. Chaudhary, that even when the matter is being adjourned, we indicate our
Correct.
understanding of the
Very
facts,
correct.
so that it's not
So the
necessary.
next, on next occasion,
for
it
the
becomes
next-
easier.
Yeah. Bali 17 हाथ में थी। And what was the price at which it was settled with respondent number 5?
84,000.
That's above the reserve price.
Yes.
That's above the reserve. price.
Yes.
Now let us please show us that clause
Yes.
12 of the.
Milord,
tender document.
first, please come to the NIT, Milord. It starts at page 27. If your lordship would kindly come to page number 28. 8, my lord. Page 28 on top, 83,000. 83 lakhs, 410. Then my lord, most
No,
importantly.
just a minute.
Ah.
You come to page 27 first. I
Yes.
don't know why do we write all this without.
It is hereby notified.
That column, that last column where you have read 84,
Yes,
that shows earnest money, and that's the reserve price.
yes.
Earnest money is
83 lakhs, 410 is the reserve price
Hmm.
and 8,30,000.
But that is shown as earnest money, not reserve price.
Yes.
Please see.
Yes, honest one, correct. Then, my lord, how do we give meaning to clause 12 at page 12? That is the issue.
ये दूसरा वाला जो हिंदी है।
My lord, difficulty is what meaning we give to clause 12 at page 30 without the addendum, my lord. Please come to page 30, clause 12. In respect of tender for all bazaar and ghat, the tender offering highest value between the average settlement value of the previous 3 years and an increase with the cap of 10% of the 3 years average value will be accepted for consideration. The minus addendum, how do we give effect to this clause?
Yes.
So, my lord, to give effect to this clause, my lord, the addendum was brought in on, it was on 16.6.
Where is that addendum?
Yes, addendum is at page 43. Therefore, we say, my lord, this entire process was wrong. Page 43. 2 from the bottom, my lord, Balikhotra half weekly, average value 14 lakhs, 1 crore 48 lakhs 350. So therefore, this has to be construed harmoniously. Otherwise, my lord, we cannot give a meaning to clause 12 at page 30. Now, when we saw that the average price should range between this price, I didn't submit my tender.
You're a seasoned bidder.
Yes.
Mr. Chaudhary, you
No,
are not.
this time I did not bid.
We have followed that. We have written that.
Yes, yes.
You have written that in.
Yes.
You say that because of this confusing statement,
Yes.
you and perhaps many others did not
Participate.
Did not participate, and therefore it was not full participation.
In fact, my lord,
Maximization of
I would
revenue.
respectfully submit, my lord,
But
because of
I
the, yes, correct.
The-
Because of the, my lord, procedure adopted, the level playing field was denied to the.
That we have said,
Yes.
level playing field has to be there, but
Yes.
then you see it from a different perspective. Now, what you showed us at page 28, what was that? Where is that chart?
Yes, my lord.
No, it was
27 and 28.
27, yes.
Yes.
Now, this is the earnest money.
Yes, last column is earnest money and the
so-
reserve price is the last but one column, government value.
No, government value in rupees is this.
Yes,
Government value is earnest, government value is reserve
the reserve price.
reserve price. And then earnest money, the reserve price and earnest money are going to be the same.
Yes, actually 10% of that.
Now, this has to be taken as the minimum reserve price. The reason why I tell you is
Yes.
this. Now, they say that it has to be an average of 3 years,
Hmm.
which would be the maximum with a cap of 10%.
Yes,
Now, the purpose was that, people should not back the contract with astronomical,
and
price,
subsequently,
which they will not be able to perform.
yes,
It is precisely for this.
yes,
Therefore, it should not have, this would be the maximum limit. Reserve was this. So your anticipation that it would be very dear and you can't participate, financial, viability, therefore you did not,
yes,
unfortunately, but it was settled for 84.
34.
So that is your problem.
Yes, no, it's not my problem.
No,
my
it's a
lord.
level playing.
No, no, my lord. If a lordship should kindly come to clause page 30, because who can be settled with it? It is clearly indicated. Who can be settled with it? In respect of tender for all bazaar ghat, tender offering highest value between the average settlement value of previous 3 year and an increase with a cap of 10% of the 3 years average value will be accepted for consideration. That means those bidder who submitted bid of the last 3 years average plus maximum 10%.
So therefore, you are interpreting it to mean
Yes,
that this was the minimum which you understood.
yes,
So minimum was average of 3
3,
and maximum it would go to 10%.
10%. Now, but when it turned out that it was settled for 84 lakhs.
ये minimum तो है नहीं है.
Can I just place one passage from Reliance's case, my lord, where it will be very.
We had
Yes.
talked about few cases to you.
Yes, I brought the Reliance matter, my lord. 2007 8 SCC page 1.
Reliance Energy Limited versus
Yes,
MSRDC.
yes. I'll rely upon two paragraphs, my lord, 36 and 38.
The minimum it had to be average. और यहाँ पर average.
My lord, for Honorable Justice Arundev Chaudhary's perusal, my lord, if I can place that vernacular at page 39.
Vernacular has to be translated.
Yes. His lordships will do it, my lord. সকলো বজাৰ ঘাট ক্ষেত্ৰত বিগত ৩টা বছৰৰ বন্দোবস্তিৰ গড় মূল্য সহিতে গড় মূল্যৰ 10% হাৰৰ ভিতৰত দাখিল কৰা সৰ্বোচ্চ নিবিদাহে বিবেচনাৰ বাবে গ্ৰহণ কৰা হবে। So there is no escape from it, my lord.
And
Let's see this paragraph in Reliance Energy.
Our translation, my lord, at page 30.
No, translation.
Yes.
This paragraph from Reliance Energy Limited.
Yes. Please come to para 36 and 38, my lord, at page 21. Now please come to Placitum C, my lord. After referring to Article 14 and 21, Placitum C, the sentence starting with, they cover various aspects of life, has your lordship's got it. Page 21, para 36, Placitum C.
Yeah.
They cover various aspects of life. Level playing field is an important concept while construing Article 19(1)(g) of the Constitution. It is this doctrine which is invoked by Reliance and so in the present case. When Article 19(1)(g) confers fundamental right to carry on business to a company, it is entitled to invoke this same doctrine of level playing field. We may clarify that this doctrine is, however, subject to public interest. In the world of globalization, competition is an important factor to be kept in mind. The doctrine of level playing field is an important doctrine which is embodied in Article 19(1)(g) of the Constitution. This is because the said doctrine provides space within which equally placed competitors are allowed to bid so as to subserve larger public interest. Then, my lord, may kindly come to the last para, Placitum Z. Article 14 applies to government policies, and if the policy or act of the government, even in contextual matters, fail to satisfy the test of reasonableness, then such an act or decision would be unconstitutional. Then please come to para 38, my lord. Now this is very important. When tenders are invited, the terms and conditions must indicate with legal certainty the norms and the benchmarks. This legal certainty is an important aspect of the rule of law. If there is vagueness or subjectivity in the said norms, it may result in unequal and discriminatory treatment. It may violate doctrine of level playing field. I am on this passage, my lord. Now, the manner in which, my lord, the tender was floated and the manner in which the decision was arrived at, there was no legal certainty. So therefore, my lord, in the process, the right flowing from Article 91(g) was denied to the bidders like petition appellant, my lord. I did not bid because I found it is very high. Eventually, I found that it was settled at the value which was indicated in the first notice. The addendum.
You can argue it in another way.
Hmm.
That you say that, well, you did not participate, that's something else.
Hmm.
You did not participate
Yes.
because it talked about the average of 3 years, last 3 years settlement.
Hmm.
But if this clause 12 of the tender paper exists and it was given effect to,
Hmm.
how was it, this was the minimum reserve price.
Exactly.
How was it affected for respondent number 5?
Precisely, my lord. That's why I said, my lord, without the addendum, no meaning can be given to clause 12. So therefore, the addendum. It was complementary of the first tender. Otherwise, my lord, clause 12 cannot be given a meaning.
Nobody. Yes, Mr. Datta.
Well, first of all, I would like to take your lordships again to page 30. Well, in my understanding, my lord, the clause 12 has not been translated correctly.
Okay.
Because if your lordship will read it in tandem with page 39, the vernacular version,
Which page do you want me to?
well, the page 30 is the English translation of clause 12.
You can let us see. Page 39. You will have understood that.
Page 39, yes.
Page 39 is the vernacular clause 12. And page 30 is the English translation.
You can give it to us.
Now, my understanding is this, my lord, subject to correction, and the honorable single judge has also gone on this line. In respect of tender for all Bazaar Ghat, the tendering authority, tender offering highest value between the average. Now, this between is missing in the vernacular. The vernacular part says that it will be last 3 years average value plus 10%. That is the highest cap.
Bhitorot.
Bhitorot is within.
No, Bhitorot is within 10%. It does not say the minimum base mark.
No, but how does it help you?
Now, therefore, the interpretation that is sought to be given.
Suppose without the cap, if we forget that cap, then it has to be average of the 3 years.
No, it has to be average of the, cap is for the maximum tender. That it does not specify any minimum value. The minimum value is the reserve price. I have to quote some value above the reserve price.
No, it says.
English translation.
If you want to give something, it must come.
Now, your lordship, Justice Chaudhary will, my lord, I am reading out to your lordship the vernacular part. সকলো বজাৰ ঘাট ক্ষেত্ৰত বিগত 3টা বছৰৰ বন্দবস্তিৰ গড় মূল্য সহিতে গড় মূল্যৰ 10% হাৰৰ ভিতৰত. That means গড় মূল্য plus গড় মূল্যৰ 10%, the maximum that specifies the maximum limit. And the reasoning of this inserting this clause is the amendment.
Then you read further. ভিতৰত দাখিল কৰা
সর্বোচ্চ নিবিদাহে বিবেচনার ভাবে গ্রহণ করা হবে. That means the bids submitted within the value of average 3 and 10, মানে average 3 years price plus 10, plus 10 is the maximum limit. And the reason is, my lord, the amendment of Rule 47, which the Honorable Single Judge has also taken into account.
What is Rule 47?
Rule 47 of the Panchayat Rules, my lord. Your lordship will find it at page 74.
You want to say that you submitted within this range. Among highest within this range.
Let's see 47.
My lord, page 74.
65.
Page 74 is the amendment of Rule 47.
Where is that? Read there.
My lord, in the principal rules, it starts with.
Yes, we followed.
In the principal rules, in Rule 47, for sub-rule 1, the following shall be substituted, namely, such hats or ferries or fisheries or pounds as are vested in or placed under the control and administration of Panchayat under section 105, 6, 7, and 8 and 9 of the Act shall be settled by inviting settled tenders, affixing port fee stamp for such amount not exceeding 10% of the average settled value of the last 3 years for the respective herds. It does not specify the minimum limit. It only specifies the highest limit.
Not
Minimum is the reserve price.
Did it. মরে গেছে মরে গেছে দিদি দিদি
तुमको मिल सके average पढ़ा नहीं चाहिए average of something. So this is the maximum. Minimum तो पता ही नहीं है. The earnest money के बारे में है कि it shall not be less than 2% of the. But earnest money to reserve price है ही नहीं. Earnest money is something. Earnest money is not. It has got nothing to do with the price. It has to be 2% of the. And earnest money they deposit only after that select.
exceeding 10%.
How is the sessions, how is the district, Justice Barua dealt with it?
Now, your lordship can find it out at page 60, the Honorable Single Judge's judgment.
Give us the paragraph.
Paragraph 16, 1(6).
This is only for 1 year.
1 year,
And when was it settled with you?
September
September last.
last. It was,
June is the last day. 36/2026.
it was to be settled from June, but for some reason, my lord, the settlement was delayed. It was settled in September. Therefore, on pro rata basis, my lord, the bid value has been, I mean, the bid has been reduced.
Much better.
And my lord, if it is a question,
Yes,
if it is a question about the ambiguity of the rules, I mean, or the ambiguity of the conditions, my lord, he ought to have filed some representation at least before the authorities, before the tender could be finalized. It was done only after the completion of the process, settlement process. And notwithstanding the fact that, my lord, there were altogether 5 bidders. It seems now that the confusion was only with regard to the appellant. Now, if he had some confusion over the terminology used or employed, my lord, he could have filed it before the tendering authority. And this amendment was brought out in the month of April, and thereafter this NIT was floated. So the NIT is perfectly in tune with the requirement of Rule 47 as it stands now. Only thing in the explained in the addendum was what will be the 10% cap. Because last 3 years average price was known to the government. Those were indicated. What will be the plus 10?
average capacity. Now this level playing field
My lord, if my learned friends, I'll just give one line reply, my lord. The matter requires consideration for the simple reason because the Assamese expression Bhitorot is used. Bhitorot means average and 10% cap. In between those who offer the bid, he alone will be chosen for the award. How does he overcome that, my lord? But for that, I have no case. If Rule 47 was good enough, then why this clause 12? My lord, therefore I am saying to give effect to the tender clause, that is clause 12, the subsequent addendum was brought in. Otherwise, it makes no sense. My lord, we cannot read a rule which results in a conclusion, my lord, which is neither intended nor it is desirable. Matter is very simple. If you have to get the contract, you must quote between last 3 years average.
But how is it? What was the price offered by others? Was it that?
Those are below. I'm not exactly aware of the prices
No,
quoted by
so
others.
you were the H1.
Yes,
You were the H1, so
I
it
was-
has to be below.
Below.
Exactly, we don't know.
yes,
All of them had participated.
yes. And if the ambiguity is to be, if there is at all any ambiguity or it requires an explanation, my lord, it will be the government, the best will be the tendering authority to explain it. The matter was decided before the honorable single judge on the day of motion itself, without calling for any affidavit. Now, if your lordship would like to further go into the matter, my lord, my understanding is that, my lord, at least the government should file an affidavit, what they meant by this clause 12.
In the
My understanding is that, my lord, irrespective of the addendum issued, my lord, it is very well clear that the highest will be last 3 years average plus 10%. That will be the highest. It does not specify the minimum limit.
Highest among these will be considered.
Yes, that's the point. Bhitorot.
If you read it like that, then Mr. Chaudhary has a point.
Yes.
Highest amongst them, that's a super clause.
No, my lord, the clause 12 is very clear. Whosoever quotes last 3 average figure is there,
How
my
do you
lord.
respond to this, Mr. Chaudhary? We understand, level
Yes.
field and understanding the
Yes.
terms of the
Right.
tender.
No,
Therefore,
my lord,
we are-
my learned friend
therefore-
submission relying upon Rule 47 by itself is okay. That I cannot say find fault with his
No, no,
argument.
please respond
But
to this.
yes,
Please respond to this. By whichever translating mode you analyze this,
yes.
this talks about the maximum.
No, it doesn't talk. Bhitorot means, my lord, the average figure is X.
मैं Bhitorot बताता हूँ.
हाँ.
Bhitor has some equivalent in Hindi also.
Yes.
It says that the maximum would be within that 10% of the average value.
Yes.
No,
It will be considered. Those people.
no, my lord.
Consider.
It will be considered.
Those bids will be considered whose bid is within that group. Otherwise not. That is creating the problem, my lord.
That's true.
So that means the intention of the tender inviting authority is clear and unequivocal.
Highest bidder. And will say that people.
Then therefore, if that interpretation is to be given, what my brother says,
Yes.
has logic, then the minimum price is the average of 3 years. Then that is the reserve price.
Yes.
And the hike would be of 10%
Yes.
maximum.
So therefore, my lord, what is indicated in
doesn't-
tender
it doesn't-
notice has nothing to do with this
That's
agreement.
true. That is because of the translation, but it doesn't make sense because then the range is too less. Average, if this is the explanation which we accept, let us look at it from all angles because you have raised a point, we must answer it.
Yes.
We cannot ignore the point saying that no, now that it has been done, it must be answered because therein lies the honesty of purpose.
Right, right.
If we can meet your grounds, it's all right. If we cannot meet, we'll have to say that we cannot meet this, but we are still not we're still not interested in interfering. But for meeting the grounds, see, this interpretation may be correct factually and literally, but then it makes no sense because the range then becomes very less. If this
Range is 10%.
just a minute. If this is accepted, then there is a reserve price. Reserve price is not 80 or anything without too many words. Average of the standard value. Average of the 3 years bid.
Settlement value.
Average of the 3 years bid. Therefore, the range is only between the average and 10%. So that perhaps is not the
No,
way.
my
in
lord,
which
that is
tenders-
the intention. That is the intention which is being conveyed by clause 12.
Price disclosed at minimum, of 10% में जो ज्यादा दे पाएगा, ज्यादा
My lord, my learned friend's argument based on rule 47, I am not disputing. But for this clause 12 and the reserve price, some meaning has to be given, my lord. That means the tender inviting authorities' intention is very clear. Over and above the rules, they have come up with this clause.
The rule 47, rule 47 is rule 47 does not say. Rule 47 कहता है such market खरीद shall be settled by inviting three tenders. Such market तो खरीद तो किसकी तो public. As has been prevailing otherwise. So prevailing otherwise. ये नहीं करिए and earnest money not below 2%. वो समझ गए तो prevailing otherwise. ये तो minimum है. ये तो minimum.
Mr. Datta, please read section 47 again with us.
Rule.
Rule 47.
Such huts or ferries or fisheries or ponds as are vested in or placed under the control of the administration of the panchayat under sections 105, 6, 7, 8 and 9 of the act shall be settled by inviting sealed tenders affixing court fee stamp for
Now, this separately.
Yes.
For such amount as has been prevailing otherwise. So prevailing otherwise, the practical aspect of coming to the prevailing prices would be average of the last 3 years and earnest money not below 2% of the minimum bid value. Correct.
No, my lord, if
Just
your
a minute.
lordship is on page 74,
No, we are at the section which is quoted.
Kitab.
Now, there could be two interpretations, but then do we interfere in this, especially when only 5 months are left? Now, prevailing otherwise. So this means that this is the minimum. This is the minimum.
no, my lord, prevailing, perhaps your lordship is
I'm reading from the what is quoted. Page.
No, in the quote in the judgment, my lord, there is some mistake.
Oh, yeah.
Your lordship can read it from page 74.
Page 74. Okay.
Yes.
Okay. Now read this again. Read from there.
Or-
Affixing court fee stamp, inviting sealed tenders, affixing court fee stamp for such amount.
Not
Not
exceeding
exceeding
10% of the average settled value of the last 3 years for the respective huts. Not exceeding 10% of the average settled value. So it only prescribes the upper limit. And the earnest money shall not be below 2% of the minimum bid value for sale and settlement of the right. to
This I
collect.
think he has quoted incorrect. Maximum.
And in the tender itself, my lord, the earnest money is indicated.
But that makes no sense, no. It has to be, then it is not in tune with section 40, rule 47. Earnest money has to be
Has to be,
2% of the bid amount.
no, shall not be below 2%.
Shall not be below.
Shall not be below 2%. The earnest money indicated is 10%. In the tender, it is 10%.
No, in the tender, it is 10%.
10%.
And what is that chart at page 28?
Page 28 only describe, identifies the last 3 years bid
No,
And,
Page
oh,
28.
sorry.
that's the tender, my lord. Where
In the
reserve
tender.
price is.
Well, that is the reserve price.
They don't write reserve price, no.
This is home.
Page 28.
Page 28, my lord, that is the minimum value. Government
Government
value.
value in rupees, what does this mean?
That is the reserve price. my
That
lord.
is the minimum value government asking for.
All right, and what is earnest money for that would be? this?
Earnest money is for that.
সরকারি নিবি।
Now it is very high. That is very, very. Now
Maximum का खाली cap किया है।
Now, since the NIT did not indicate the last 3 years average price,
they clarified it by.
they clarified it in the subsequent.
With a rider, ভিতরত।
So only you are the one who understood it that way, otherwise.
Oh,
all
Lord,
others-
there are,
No,
there are
as
four
long
other
as, as
scholars-
long as I understood it correctly, my lord, that will be sufficient.
there
If
were
your
four
lordship
other
goes otherwise, that's a
scholars
different thing.
who understood it in the same way.
No, my lord, here in this case, but for this clause 12 in the tender, I don't have a case.
No, that's all right, but ambiguity here, if at all it exists.
No, my lord, all that is
We'll
required
go
is
for
there
the-
will be,
we'll
there will
go
be a
for-
fresh tender, that's all.
No,
I'm not
we'll-
asking for,
We'll go for the concluded contract, no, for the reason that there could be, you argue.
no, my lord, it's only September, 3 months only he has operated.
It's only for one year, no?
Yes, 3 months he has operated. Now, if the contract is settled within another one month, it will be over. By February 15 itself.
Now, as suggested by Mr. Datta, what is the state response? What did you mean by this?
My lord, being the representative of the government, my lord, although I'm not happy with the rates, but my lord, my understanding is also that, my
Why
lord,
do you have to begin your argument with this?
because
If you're not
we are
happy, then say
receiving
that we
lesser
don't
amount.
Let us have maximization or whatever.
My lord, we are receiving lesser amount. That is why I am
It
saying
is
that.
not always helpful in being very forthright and honest.
My lord,
You can't disclose this. You are here to defend the government.
my
Now
lord,
you tell us what
Yes,
the,
yes.
what the tendering authority meant.
my lord. My lord, first thing, my lord, that translation was, my lord, made from the vernacular one. And the vernacular one, my lord, was incorporated from the rule only, my lord. Rule 47 is the base from which that line was incorporated in the tender form, my lord. And rule 47 is saying only about the highest value, my lord. No minimum value was prescribed. In fact, the tender, my lord, itself started from saying it is as per the provisions of Assam Panchayat Act 94 and Assam Panchayat amended rules, my lord. Therefore, my lord, if in rules it's not permissible that there is any minimum value, then that perhaps translation is not correct for my understanding, my lord. And petitioner, my lord, appellant never participated in the.
That is
Yes,
that
yes.
is not disputed.
Otherwise, also he.
Does he say that he participated?
Otherwise, also he thinks that he cannot participate, my lord, in that value, in between
That's
that,
right. So therefore the argument with respect to level playing field
my lord,
and ambiguous terminology in the tender papers, that is why he is arguing.
my lord. So my understanding is that 47 is saying about only highest value, my lord,
But
no
what
minimum.
you settle for, I mean, exactly the same amount as government, even much below than 3 years average.
That is very unfortunate, yes, my lord.
No, my lord, I'm sorry to interrupt, my lord. It was not 3 years average. Because I am getting it for only 9 months. That's why the bid was on pro rata basis it was reduced.
Yes, that is also correct.
It is reduced on pro rata basis, not that I was given.
Deducting the initial amount.
The price offered.
Price offered was, my lord, 84.
So
Right, the government reserve price was 83.
what is price offered?
Price offered is what? Must be the highest, which is
84.
84.
Price offered was 84 because reserve price was 83. I offered 84.
We have. What what is holding us is that there can be no two opinions that with this kind of wording, if you lift some paragraph from some rule, put it as an addendum, it creates confusion. It does. But then if Mr. Datta would have been the only bidder, it could have been understood. There were 5 others.
Yes.
And 5 months left. Let's go for the concluded contract. We would acknowledge the fact that interpreting it, I mean, there could be some confusion, but it was not such that should have prevented a ready bidder with experience not to participate. Your bid would have been rejected.
Yes.
Your bid would have been rejected. That's your that's called brinkmanship, no?
And I leave it to lordships, but my lord, here is a case.
No, you did make us think. I
Yes.
mean, there is no difficulty about it. That argument was not without substance. But we are not interfering for very many other reasons. One, Jagdish Mandal weighs very heavily with us.
Correct.
Jagdish Mandal weighs very heavily with us.
Michigan rubber is also there.
Huh?
Michigan rubber case is also there.
Michigan rubber is something else, but Jagdish Mandal says, keep your hands off. More or less, this is the expression used. Keep your hands off.
My lord, my learned friend has made the argument he never filed any affidavit. So it was his personal agreement. This was not the view of the government. Let us be very clear about it. Otherwise, why government came up with that addendum? To give effect to clause 12. And who has drafted clause 12? It is the government. Whether it has been lifted from rule 47, that is not our lookout. When we as a citizen, we as a tenderer, my lord, view at it, we test it legally. Or let him offer his rate, my lord. Increase his offer. Let him pay the minimum. Yes. Yes. My learned friend should have argued that. Had I been in his place, I would have said. He admitted that government has committed a mistake. Therefore, now let them pay the highest value, not 84,000.
Mr. Chaudhary, you can't frame it in your wisdom and experience. You can't frame a young
I'm
person
not saying
like
mistake,
this.
my lord.
He has made a statement. We accept it in its different perspective. He has said that.
Yes.
Let us not
I leave it to lordships, my
find
lord.
somebody to a statement which. Therefore, I told him in the beginning, immediately, as a standing counsel, you should not make this statement.
Yes, yes. That is a different way.
You said
Yes,
that.
yes,
We understand it. Many times we say many things,
Yes, yes.
but he can't be pinned down by that. That way, you will make younger advocates, shudder before they speak. No, Mr. Chaudhary, you have to mentor. You don't have to discourage.
No, I do that. There's nothing like it.
All right, next time, be more adventurous. At least you could have participated. Then you could have participated. I mean, you should have participated. But, there is some sense, but we now are leaning in their favor. Clearly, think that. We have heard Mr. K.N. Chaudhary, Leonard Senior Advocate, for the appellant.
With your lordship's kind permission, can I take leave another?
Please.
My friend would be there.
Heard Mr. So-and-so, Leonard Senior Advocate for the appellant. Mr. S. Datta, Leonard Senior Advocate for the for the respond number for respond number 5, and Mr. S. Datta again, standing counsel PNR. Correspondence number 1, 2, and 4. The challenge in the present appeal is to the judgment dated 10/11/2025, passed by a London single judge of this court in WPC number 6324 of 2025, whereby the settlement of the bazaar in question with respond number 5 has not been interfered with. A tender notice was issued on 7/6/2025 by the Chief Executive Officer at Nagaon Jilla Parishad for settlement of various markets under the Parishad for a period of 1 year, that is from 2025 to 2026, with effect from 1/7/2025 to 36/2026. The tender in question is with respect to Bali Satra half-weekly market, wherein the government value of the said market was declared to be around 83 lakhs. Clause 12 of the tender notice clause 12 of the tender notice indicated that in respect of tender for all bazaars/ghats, the tender offering highest value at the rate of the average of settlement value of previous 3 years, along with an increase within the cap of 10% on the 3 years average value, will be accepted for consideration. Will be accepted for consideration. Later, an addendum was brought about indicating in detail the average value of all the ghats which were put to tender, along with a figure which indicated the 10% increase on such average value. The appellant did not participate in the bid, despite his being a seasoned bidder for ghats.
It will be hard. HAT.
Ghats, choro hard. Everywhere it is hard, not ghats. We are reminded of our sand ghats. So, hard. Yeah. What did I say? His being a seasoned bidder who had participated in such bids earlier and was also with all preparedness, only for the reason that he understood the terms of the tender differently, which, according to the appellant, was the only logical conclusion of the wordings used in the tender papers. Perhaps the appellant meant that the minimum value of the tender would be average of the last 3 years, with average of the last 3 years, and the range within which bids have to be offered would be within the average of the last 3 years settlement, with only a 10% cap and not beyond. The average of the 3 years, the average of the last 3 years settlement was more than more than a crore, more than a crore. This assessment of the minimum price prevented the appellant from participating in the bid. When the bid was settled in favor of respondent number 5 at a much lower price, which was only slightly higher than the government price of the heart, the appellant chose to question the tender process by alleging that the terms of the tender were confusing, vague, and thus leading to lesser participation and consequently no level playing field. Mr. Chaudhary contends that this confusing clause in the tender document in a way breached the essentials of Article 19, 1G of the Constitution of India. The learned single judge, while dealing with the issue, found that clause 12 was basically in consonance with the provisions contained in page number
74. Page number 74.
provisions contained. What is the name of this legislation?
So that is Assam Panchayat Rule Financial Rules. 2002. 2002. Amended in 2025.
What did I say? Clause 12 of the tender paper was in consonance with amended Rule 47 of the Assam Panchayat Financial Rules of 2022, which provided the maximum, which only provided the maximum price for which a hart or ferries or fisheries or ponds could be settled. Could be settled. This clause could not have been misread to understand that the minimum reserve price would be the average of the last 3 years' settlement. The minimum reserve price has not been indicated in the tender papers, leaving it open-ended. The only stipulation in the tender paper is with respect to the government value of the hart in question and nothing beyond. However, we find from the tender papers that the earnest money also has been indicated for all such harts, which also was found by the learned single judge to be in consonance with the mandate of Rule 47 of the Assam Panchayat Financial Rules 2022, as it prescribes that the earnest money ought not to be less than 2% of the bid amount. 2% of the bid amount. The contention of the appellant was rejected by the learned single judge. On the grounds that there was no participation, that the appellant had never participated in the tender, and that there was little scope of any other interpretation of the clauses of the tender, which had to be in accord with the Assam Panchayat Financial Rules 2002. Mr. Chaudhary contends that there is an ambiguity in the tender clauses, which could mean that the reserve price, which would be the minimum reserve price, which could mean that the minimum reserve price would be the average of the bid settled for the last 3 years, And the range from which the bidders would be selected would be within the, would be within the range of the average of the last three settlement amount and 10% cap over and above that. So this understanding only prevented the appellant from participating in the bid. He further submits that if any terms of the tender is likely to cause confusion, it vitiates the process for primarily the reason that it would prevent fullest participation. In the present case, it has been pointed out that the bid of respondent number 5 has been settled at a very low price, perhaps the lowest in the last 3 years settlement. Thus the ambiguity in the tender paper leading to confusion has prevented fair competition. Fair competition. That he did not participate in the tender would not render him disentitled to question the process, as the issues raised by him would fall in the domain of public law review and private grievance. To stop even otherwise, Mr. Chaudhary argued that mere non-participation in a tender would not oust a person interested in participating from questioning the correctness, from questioning the fairness of the process of selection. There could be no dispute about the aforementioned proposition. However, on examining the tender document, especially clause 12, read with Rule 47 of the Assam Panchayat Finance Rules 2022. 2002. It becomes very clear that what was indicated in the tender document was the maximum price, which perhaps was necessary for avoiding tenders with exaggerated amount which would never be fulfilled, but no minimum reserve price, or else it would have been mentioned. True it is that in the wordings employed in clause 12, there could be a possibility of confusion that the minimum price would be the average of the last 3 years minimum. But then, whether it has led to non-participation of many other ready tenderers, many other interested tenderers, is a question which is to be decided from the, is a question which is to be gleaned from the surrounding circumstances. So the records reveal that there were 5 participants in the tender, but respondent number 5, the bid of respondent number 5 was the highest, even though low by the previous precedents. Nonetheless, previous precedents. in Reliance Energy Limited versus Maharashtra State Road Development Corporation Limited, 2007, 8 SCC, the Supreme Court, while enumerating on the various facets of Article 19 of the Constitution, explained that level playing field in all its spheres of constitutional and fundamental rights is an important concept, and it holds special relevance for construing Article 19, bracket 1, bracket G of the Constitution of India. When Article 19, 1G confers fundamental right to carry on business to a person / company, it is entitled to invoke the said doctrine of level playing field. However, it was clarified that this doctrine is subject to public interest. Public interest. The law with respect to tender is also very clear. When tenders are invited, the terms and conditions must indicate with legal certainty. Must indicate with legal certainty norms and benchmarks. The legal certainty within courts. The legal certainty is an important aspect of the rule of law. If there is any vagueness or subjectivity in the said norms, it may result in unequal and discriminatory treatment and thus violate the doctrine of level playing field. Level playing field. However, after saying this, we need to emphasize that it was not a case of single participation. There were many participants, and perhaps all others except respondent number 5 had offered lesser bid than respondent number 5 for him to be selected. Thus, for the majority of the bidders, the clause 12 of the tender document did not create any confusion with respect to the minimum reserve. That apart, very strong reasons are required for any interference with the concluded contract, as the sanctity of a concluded contract is also an important facet of an effective fiscal administration of the state. Seen in this perspective, we do not wish to interfere with the judgment of the learned single judge. We also say this for the reason that the contract period also has substantially been consumed, and only 5 months are left for the contract period to be over. For these reasons, we dismiss this appeal, but there's no order at the court. 47 bracket 1.
I love it.
Thanks. What is the next one? 16, Brahmaputra Board.
Not 12. Item 12.
Well, item 12, I am there for the respondent. Your lordships had heard the petitioner's side. I am only to make my submissions.
Please. Start your submissions and then we go for lunch. We come back again with renewed energy.
Yes.
Anyway, we started at 2.
Obliged.
Only 3. All right.
Item 12.
Please, your lordship. Now, the matter is with regard to the entitlement of benefits under ACP scheme, ACP MSCP scheme. The petitioners took a point that the persons who were appointed on higher pay scale would not be entitled to the benefit because their past services would not be considered.
You are supposed to tell us
Yes.
whether those 24 out of those
Yes,
24
out of,
serving employees.
my lord, we have filed an affidavit.
Hmm.
And there we have indicated, my lord, out of the 24 persons, there are only 3 persons now. Namely respondents number 10, 11 and 12 who have been serving in higher pay scale.
10,
11 and 12. They have been serving under on higher pay scale. And respondents number 18, 21 and 22, they have been serving, they are group C employees. 10, 11, 12 are group B and respondents number 18, 21, 22 are group C employees. They are also serving on a higher pay scale. These are the 6 persons only out of the whole lot of respondents. Well, most of them have retired or in many cases.
So then the information is incomplete, Mr. Datta, no? Those who have retired, nothing can be done.
Yes.
No recovery otherwise. No
Yes.
recovery from anybody.
Yes, that they have also stated, my lord, on the last occasion, your lordship.
Where is the difficulty? If there is no recovery from anybody and if you have retired, but henceforth nothing.
No, there I want to make a submission, my lord. There I want to make a submission, my lord. The basic case that was espoused before the honorable tribunal was that there is a office memorandum which says that we will be entitled to the benefits of ACP and MECP on completion of certain length of service. Now, after we were absorbed, we were previously employees of the government of Assam.
So that we have stated.
Yes. Now, after we were absorbed, there was a terms of absorption. Now, the terms of absorption maintained that we will be entitled to count our past services for the purpose of pension and all other benefits. Thereafter, the benefits of ACP was conferred on us. That was sometime in the year 2006. 2006, commencing from 2006 up to 2009, on various dates, my lord, the benefits were conferred. Now, thereafter, in the year 2012, there were some queries raised from some quarter as to whether we would be entitled to it or not. And in fact, my lord, on 27th of February 2012, they issued a circular saying that we will be entitled to benefit because maybe the terms of absorption were so. Still thereafter, my lord, there was a circular on 25th of October 2012 when they took a different stand that these benefits have been conferred upon you on a mistaken notion and hence there would be a recovery. Now, this particular office memorandum of 2012 coupled with one of 8 July 2015, these were put to challenge before the CAT. While entertaining that challenge, my lord, what the Honorable CAT has done, they have taken reference to a previous decision of the tribunal, which eventually got upheld by this Honorable Court. Now, there also, my lord, in that particular case, the situation was the employees of this High Court, they went on deputation to Central Administrative Tribunal. And that naturally, that involved a deputation to a higher pay scale. and they eventually got absorbed there. The plea taken by the Union of India was that since you are coming on a higher pay scale and since you are coming on deputation and then getting absorbed, so by operation of clause 6 of the Office Memorandum 2000, you will not be entitled to the benefit of past service. CAT set aside, not only set aside this Office Memorandum, but also eventually passed a direction to confer the benefit of counting past services on us. This came to be challenged before the Honorable High Court. The High Court upheld the decision. Now, the petitioners are now taking up stand that the order of the Honorable High Court in the previous round of litigation was silent as regards the consequence of setting aside of the order, setting aside of the OM dated 10/2/2000. And therefore, it cannot be read as a indicator that, in fact, the setting aside of the OM was upheld. They therefore want to say that notwithstanding that aspect of the matter, in this round of litigation, it can still be gone into, this issue can still be gone into, and eventually, since some of us did not go there on, some of us did go there on higher pay scale, so our benefits should be recalled for future purpose. My submissions are basically twofold on this point. First of all, Milord, the issue that arose, or the issue that is involved here, that is precisely whether, or in the face of that particular clause, namely clause 6 of the Office Memorandum, we are entitled to count our past services or not, notwithstanding the fact that whether we have gone there on higher pay scale or equivalent pay scale or lower pay scale. My submission is that, Milord, this issue has been clearly decided in the previous round of litigation. Although, Milord, the Honorable High Court did not say it in so many words that the OM dated, the setting aside of the OM dated 10th February 2000 is upheld, but in effect, Milord, the order is so. Because the order says that notwithstanding the fact that there was a difference of pay scale, the persons who have gone from here to the CAT, they will be entitled to count their past service. That issue has, in my submission,
I don't think my learned friend can re-argue. My learned friend wanted to give a affidavit, which also was misplaced, saying that they had joined on the same pay scale, or they had been working.
MS Luthra, allow him to complete. We are aware of that. Allow him to complete.
Now after this has come, because the dispute centrally around, principally, centered around the issue whether we went there on higher pay scale or not. Well, my learned friend has put up a record indicating that who went there in which category of post. I have in my supplementary affidavit, I have only indicated the persons. Well, that depiction is correct, because as far as the category of posts are concerned, I have additionally indicated in my affidavit whether the pay scales were analogous, lower or higher. And if I am to read out, my lord, I'm sure, my lord, my learned friend has also received a copy of the affidavit that we have filed.
Have you received the copy of the affidavit, MS Luthra?
Yes, my lord. But what I have understood from it is that my friend is saying that they were working at higher pay, though the pay scale was lower. And that I have a issue with, because all he has to talk about is the pay scale.
Now, my lord, I have in my affidavit, I have indicated, my lord, if your lordship will, perhaps, my lord, I need to go in somewhat details, my lord. If your lordship will kindly take up page 262 of my affidavit, my lord. Here I have indicated the pay scales which the petitioners were enjoying. 262.
Yes.
But in this chart, my lord, we have indicated the pay scale at which, my lord, the respondents were working under the state government and the scale to which they were appointed. Now, if your lordship will just go through this chart, my lord, clearly, at least from the persons at serial number 29 onwards, they went on lower pay scale. From 29, serial number 29 onwards, my lord, they were all on lower pay scale. In the state government, their pay scale was higher than that of the pay scale in the ESIC. As far as the other people are concerned, my lord, although, my lord, some of them, most of them have retired by now. And there was only one person, my lord, respondent number 27, who went on equal pay scale. And this we have reproduced on the basis of a letter issued by the ESIC, which your lordships will find at page 270. That was the letter issued by the ESIC indicating the pay scale to which, my lord, the persons were absorbed.
That shall be verified by the ESI. And if it is so, there will be no recovery, but no further payment.
No, so now, my lord, taking a
And no recovery if you are class 3 or class 4. Otherwise recovery.
my lord, in that circumstance, there appears only three persons, that is respondents number 10 to 12, who are in group B, that is class 2. Rest are all, my lord, outside the.
That will be verified by ESI.
Well, that is on the basis, my lord, whatever we have said in the affidavit, my lord, that is on the basis of the document.
That's right.
Yes.
So we are not going to state the names of those persons. We
Yes.
will only say that this policy would be effective in this manner.
Now, question is, my lord, whether in this round of litigation, your lordships will be again going into deciding the validity of their action. Because the fundamental basis of their action is an office memorandum dated 10th of February
Which was,
2012.
which was presumably set aside in Kushal Sharma.
Yes.
And Kushal Sharma's verdict was approved by the High Court. That does not mean anything. We are not saying anything about that. We have said that it was a mistake, and mistake does not mean that it should be perpetual.
My lord, here my submission is that, my lord, this will constitute an estoppel cause of action. Because the cause of action of 10 to 2000 office memorandum gave rise to a cause of action.
No.
And that cause of action, my lord, that got decided on merits. The High Court said, the tribunal said it clearly in the order that the OM dated so-and-so is set aside. If your lordship will just refer to page number 158, the eventual directions of the tribunal was very clear. And it is not only the case with the Northeastern region, my lord. In other parts of the country also, my lord, my learned friend has said that in Delhi High Court and in some other High Courts, my lord, a different view has been taken. But as a matter of fact, my lord, we have also brought it on record by way of an affidavit that in Rajasthan High Court, my lord, the decision was just in line as the Guwahati High Court had decided in the previous occasion. And that those orders also have attained finality. Now, if your lordship will kindly turn to page 158, the last paragraph, five lines of paragraph 11, accordingly, we set aside and coerce the impugned DOPT letter dated 10 to 2000. Now, this cause of action pertaining to 10 to 2000 comes to be decided in this way, eventually upheld by the High Court. And there is no further appeal carried by the respondent. Naturally, they would have been in a position to say that this setting aside was not proper. It was a plea available to them.
Yes. Yes, I must do.
My lord, may I be permitted to place two decisions, my lord, in support of my country?
Please do.
My lord. Okay. My lord, my first reliance is on this decision 1991 SSC 193 para 26. Paragraph 26 at page 205.
Yes, read it.
My lord, paragraph 26, it is settled law that normally a decree passed by a court of competent jurisdiction after adjudication on merits of the rights of the parties operates as res judicata in a subsequent suit or proceeding and binds the parties or persons claiming right, title, or interest from the parties. Its validity should be assailed only in an appeal or revision as the case may be. In subsequent proceedings, its validity cannot be questioned. So now, my lord, the respondents cannot come and say,
This was a good argument to you when the matter was placed before the court on review. This was a good argument. to you. Yes, next.
next is, my lord, 2005, volume 7 SCC, page 190. I would place reliance on paragraphs 18 to 24, particularly 24. Now, my lord, the question of estoppel on the issue, my lord, that is discussed here.
Which paragraph?
My lord, paragraph 18 to 24. 18 will be at page 198. In reference, starts with in the reference code. May I read it, my lord? In the reference court, or for that matter, the High Court exercising its appellate jurisdiction under so-and-so could not have dealt with the said question. The principle of res judicata is a species of the principle of estoppel. When a proceeding based on a particular cause of action has attained finality, the principle of res judicata shall fully apply. Reference in this regard may be made to Whedon Forsyth on administrative law, wherein it is stated, one special variety of estoppel is res judicata. This results from the rule which prevents the parties to a judicial determination from litigating the same question over and again, even though the determination is demonstrably wrong. Except in proceedings by way of appeal, the parties bound by the judgment are stopped from questioning it. As between one another, they may neither pursue the same cause of action again, nor may they again litigate any issue which was essential element in the decision. These two aspects are sometimes distinguished as cause of action estoppel and issue estoppel. I'll read paragraph 24.
Yes.
Yet again, in Arnold versus so-and-so, the House of Lords noticed the distinction between cause of action estoppel and issue estoppel. Cause of action estoppel arises where the cause of action in the later proceeding is identical to that in the earlier proceedings. The latter having been litigated between the same parties or their privies and having involved the same subject matter. In such a case, the bar is absolute in relation to all points decided unless fraud or collusion is alleged, such as to justify setting aside the earlier judgment. The discovery of new factual matter which could not have been found out by reasonable diligence for use in the earlier proceedings does not, according to the law of England, permit the latter to be reopened. Issue estoppel may arise where a particular issue forming a necessary ingredient in a cause of action has been litigated and decided, and in subsequent proceedings between the same parties involving a different cause of action to which the same issue is relevant, one of the parties seeks to reopen that issue. So my submission is that here also, just like the previous proceeding, the OM dated February 10th February 2000 was the ingredient, one of the ingredient, and that issue has attained finality. Now, the petitioners herein cannot re-agitate that the finding arrived at before in the earlier proceeding will have no effect at all. They in fact, in essence, my lord, in my respectful submission, they are trying to raise a collateral challenge to the previous decision of the honorable court. That is not permissible. But this particular decision has also taken note of an earlier decision of the court.
I think we just from another angle, Mr. Datta. Our pay scale, and now for the time, if we forget the poem of 2000, the higher pay scale, that the financial upgrade, which to a large extent could be called in situ financial upgrade, that perhaps counting the services, the state would make you unnecessarily justified
Enrich.
richer.
Well, but my lord,
reason, for the reason that is ATMs are only the financial equivalent of promotion, in situ promotion
Yes.
even. So that I think that there is a justification for the PIC, the employer, where you are absorbed, to come out with this note that you will not be given any leave.
no, ECIC has not come up with this notification. This notification has been given by the Ministry of Personnel,
No,
which they want to
still
adopt.
personal. ESIC is only following it.
Now,
It's under an obligation to follow that.
now, Millard, ESIC, therefore, Millard, I would like to draw a line of distinction here because the entire thing has to be viewed from the standpoint of the terms of absorption. It was not that we went there in our own volition and we got ourselves admitted there, I mean, absorbed there. There were terms of absorption framed because we were working under the hospital, which was run by the state government. Now, ESIC took over that hospital and in reference to the terms of absorption, my lord, they took up the hospital along with the staff. It was a situation like that, where, my lord, the definite terms were drawn. And my learned friend has also filed an affidavit indicating the terms of absorption, my lord. I'll just read out that for a moment, my lord. I'll just read that out.
Satisfaction will see that also. Where is that?
My lord, your lordship will find the terms of reference, terms of absorption. And it was contingent upon exercising our option. We had to give an option that we will have the benefit of counting past service, then only, and it was our specific plea before the tribunal as well as before this honorable court, not denied by them. The lordship will kindly see the. I am pointing out the pleading first, Miller. The terms of absorption, your lordship will find at page 39, clause 7. May I read, please? Clause 7. An employee on absorption in corporation service shall have the option to get his past state government service counted for combined pension in ESIC if the state government pays the entire amount of proportionate pensionary liability as per central government pension rules. An undertaking from the state government would be necessary in this regard, that they would discharge their pensionary liability as per central civil service pension rules within a reasonable time. Option by the employee in this regard shall be exercised within 6 months from the date of issue of absorption letter to the employee in the corporation service. Now, in our petition, page 19, the very first line, my lord, the pleading goes that we had exercised our option to count our past service, and accordingly we were appointed absorbed in the ESIC. Your lordship will find that pleading in page 19. Page 19 of the writ petition. 19. That is a copy of the OA filed, and this pleading we have also repeated in the affidavit in the present proceeding. This was our pleading in the writ petition. The original application. Accordingly, all the applicants had submitted their option for counting of past services. Moreover, the respondent corporation also agreed to grant seniority benefit. Now, the scheme was that you come here, regardless of the scale and other thing, we are taking up your hospital from the state government. We are taking it up along with the employees, and we'll take the employees in the appropriate cadres, protecting your past service. Even they passed orders saying that if the pay is higher, if in the state government we were being paid higher pay scale, that will be protected as personal pay. So on that consideration, my lord, we changed our position. Now, how they can take a stand now at this distant point of time, after having granted the benefit for 7 years, 8 years? And based on this, Miller, they issued orders on as back as on 27th of February 2012, saying that we'll be entitled to the benefit.
All right, yes.
Now, your lordship will kindly see that order. 27th of February, my lord, at page 269. This was their own letter, and the same by the same very person who had later changed the stand. Page 269. Second paragraph. May I read it, my lord?
Yes.
State government employees who were absorbed in ESIC are eligible for grant of financial upgradation under MSEP scheme by counting the eligible period of service from the date on which they entered into service, including the service rendered by them in the state government. However, the promotion, financial upgradations, if any, earned by them during their service in the state government will also be counted. And right from 2006, since our absorption 2006, we had been all along getting it. 2015, after 19 years, they wanted to change the scenario. That made us to move the CAT again. And in the writ petition also, my lord, in the draft of, I'm sorry, my lord, the terms of absorption, which was finalized, my lord, at page 35 also, your lordship may kindly see. In case an employee opts in favor of counting of his past service, he will be eligible to draw pension in accordance with the rules of ESI Corporation for the combined service under the state government and under ESIC Corporation on the final retirement, superannuation, voluntary retirement from ESI. So they made it very clear from the beginning that our past service will be counted. Now, you cannot now say that past service will be counted for the purpose of pension and not for the ACP. That will, in my respectful submission, make the things contradictory. So therefore, my lord, the applicability of the OM dated 10th of February 2002 has to be seen in the light of the terms of absorption, following which we went there.
All right.
The another judgment, my lord, that I would place almost, my lord, in the same line. But 2005 NSCC page 51, para 42. Well, that is whether because the point can very well be asked by them that in the previous litigation we were not the parties, so the applicability of their judgment cannot be enforced in the manner we are seeking to do. Just to address that point, Lord. Para 42. In order to sustain the plea of res judicata, it is not necessary that all the parties to the two litigations must be common. All that is necessary is that the issue should be between the same parties or between parties under whom they or any of them claim. So it is irrespective of whether we were party to the previous round of litigation or not. The issue that got settled in the previous round of litigation is binding on them. They are relying on the judgment of Kunhai Ahmed in 2000, volume 6, SSC 359. well, paragraph 44 of that judgment is very specific. They are saying that it is the final order of the High Court which will prevail, not the order of the CAT. But what the final order of the High Court has really done, final order of the High Court has, in effect, my lord, has upheld the validity of the order. Because unless and until, my lord, clause 6 is ignored, there was no way out to allow the petitioners in that case to avail the benefit of past service. So the High Court may not have spelled it out in so many words that the WAM, the setting aside of the WAM dated so-and-so is also upheld. But that is the reality, that is the effect. Because without interfering with clause 6, my lord, that benefit could not have been given.
All right.
Well, in my respectful submission, my lord, although factually, my lord, there are only 3 employees remaining now, in respect of whom supposed course correction can be taken as per the statements made by them.
And they are of class 3, group 3.
No, they are of group B. 3 persons only of group B who are remaining in service now. And all other persons have either retired, died, or they are belonging to group C and D. So course correction is possible only in respect of 3 employees now, as on date. And that too, if your lordships will allow them to take it out of the clutch of the previous order. So my respectful submission is that that issue cannot be gone into at this stage. My lord has said that I could have argued this in the review. My lord, the review, of course, my lord, the petition, I mean, the order is has not recorded that submission, but the view of the Honorable Court was that this, if the petition is taken up for hearing, this point can always be argued because it's a question of law. Ultimately, my lord, it's an issue.
All right. Yes.
Which they have come.
Yes, please. You
Yes,
have to say
my lord.
anything?
So, my lord, my friend is re-arguing a case which
You
I
argue your case. Leave Mr. Datta to what he has done. That is his discretion. No, you argue your
yes.
case.
So what I'm saying is, your lordship.
Now, can an advocate argue if the judge is not ready to hear? He argued, I heard. Now you just respond to what he has said.
Your lordship is too kind. That's all I can say. What do I say beyond that? But may I just say one thing?
Yes.
That on 26th November, your lordship had dictated the main order. And that is very clear and categorical. All that your lordship wanted me was to, and this is Delhi's pollution, sir, which is doing it. Your lordship is fortunate to be in Guwahati, and so we have a cough which nobody else has in Guwahati. All I am saying is that here we had to give a list of the employees which, according to us, were not retired, were not, and what we were doing. So, your lordship, in the last few paras of that 26th November order, after holding, and I don't know how he can be asking, firstly, we went to Supreme Court. Supreme Court asked us to file a review. We filed a review. The Honorable Court was pleased to allow the review. I don't know how he is putting the cart before the horse, and everything is now done and dusted, how he can be making these submissions. But the bottom line is, your lordship, on page 5 of 7 of your lordship's order dated 26th November, your lordship had noted, while the respondents were continuing in their service under ESIC, a clarification was made by way of communication dated 1910 and 2510, which clarified that any absorption is made with a higher pay scale. Then such appointment absorption should be treated as direct recruitment, and in that case, the employee's past service shall not be counted for grant of benefits under the ACP MSCP scheme after absorption. This was by virtue of the clarification referred to above, namely number 6 and 25th Memo 10/2000 of DOPT in the Ministry of Personnel, Public Grievances and Pensions, Government of India. There was yet another internal communication dated 8/7/25 in which it is clarified that in cases where the entry pay scale in a particular cadre in the ESIC was higher than the pay scale drawn by the employee under the state government, then the employee would be granted the entry grade pay scale as per ESIC norms. Under such circumstance, service in the pay scale would commence from date of absorption for purposes of granting benefits under ACP and MACP. Mrs. Luthra, learned senior advocate for petitioners, submits that in most of the cases, absorption was on a higher pay scale, even though the nomenclature of the posts appeared to be analogous. In that case, the clarification 6 and 29 in the office memo issued by the DOPT has to be given effect to, and that any decision in another case of such absorption where a mistake was committed cannot be the basis for perpetuating the mistake, for it concerns finances of ESIC, which is by and large public money. Clarifications are self-explanatory, and what was required was a clear identification of cases who are absorbed on higher pay scale were granted benefit of ACP, MACP, while they continued working in the ESIC. Because of the litigation in the meantime, the ESIC, the said exercise could not be carried out. However, today, Mrs. Luthra is informed that 53 of such employees were wrongly given benefit, out of whom 29 persons have retired. She submitted that because your lordship had asked me what we wanted because of Rafiq, I had said we will not be doing recovery. It's only future correctional. Now it will be an exercise which ESIC will carry out. If it's higher pay scale, I will correct for future. If it's lower, if it's the same pay scale, obviously there won't be a correction. This was the only, in fact, my learned friend had not to file any affidavit. He, in any case, on 7 January said, I want to file affidavit. Then he's filed this affidavit. Be that as it may, the only principle of law is that we are not doing recovery for past. But if it is a higher pay scale, we are entitled.
MS Luthra, across the board, you will not start recovering, then Mr. Datta may not insist for any further argument. Because some of his clients are Group B, class 2.
Lord,
you make a declaration.
Class 2, I'll have to take instructions. I'll have to take instructions, class B. I said CD, and I had said, my lord, I can't do that. That will have to be, because ultimately law is very clear. Rafiq says C and D.
Now you understand the reason why Mr. Datta was arguing his case, no? Even if
no,
it be
but
for
Mr.
1%.
Datta can't argue. My lord, Mr. Datta can't argue. Rafiq is so clear. Your lordship asked me that Rafiq will apply. I said very clearly and with utmost humility that very well in those Rafiq will apply. Those who are retired, we are not recovering. But with regard to Group B, we'll have to do correctional.
Class 2.
Class 2, I can't do that. My lord, I'm a public
nobody's asking you. Nobody's asking you to do that. They're only telling you the justification of hearing the counsel. That's all.
Ah, yes. My lord, hearing your lordship is always justified. We are so fortunate if your lordship hears us. Why should I complain if my colleague is being heard?
Yes.
That is our good fortune. All I'm saying that this issue is foreclosed. There is Supreme Court judgment, Ramachandran, which was pointed out on that day, that if a person joins on a higher pay scale, then he can't get the benefit. Then it is treated as a direct recruitment. If he
So his
joins,
argument, just a minute, his argument in some substance is that you have come out with some non-statutory clarification which cannot override the letter of absorption, the mandate of absorption. That's what he has argued for all this while.
the letter
And
of
therefore
absorption nowhere
therefore the
says.
reference to the two cases.
My lord, they had the option whether to come in ESIC or to continue with state.
No, what is the question of option? Option they have exercised. Seeing the terms of the absorption, they exercise
But the terms of absorption don't say that. I don't know where he's saying this from. I can't find it, but the terms of absorption don't. The terms of absorption don't say that a higher pay scale he'll get. Then
No, it doesn't
DOPT
say that.
circular
It
would
says that
go.
if you're absorbed.
My lord, all the judgments are this. I have given your lordship 10 judgments, which is
No,
why your lordship.
we are prima facie in agreement with what you're saying. We have said so in our order. The stand of ESIC appears to be very fair. So why do you worry now? Now conclude your arguments.
Lord, that is what I have to say ultimately. I have given your lordships.
So you have
which
you
is
have
the page he is referring. My
you-
lord, can I see which document he's referring to?
one second. You have only 3 persons to act upon. Take a decision. We are not going to do anything. For rest, we are absolutely with you. Don't recover if they are class 3 or class 4, which also I don't think is a correct proposition, but notwithstanding Rafiq Masih, there are cases later, but then we'll go by what you say. And
A lot of the cases, the courts have said past arrears will not be taken, future they can be taken. But I had, since Rafiq Masih said this, I said I pointed this out to ESIC, but regarding the other people, because see, this is a matter of policy. Every day, state government, it's not one case. It is state government hospitals are being taken over by ESIC everywhere in the country. This is going to be a bad precedent and incorrect in law. DOPT circular of 20th
why did you not question Kushal Sharma?
What Kushal is not even saying this. I had explained this on the last day to your lordship. Kushal is not even about this.
Kushal is not saying this, but Kushal relies
Kushal
on
is
the...
not about this. My lord, Kushal is not. It was misunderstood by the court. And the reviewer has covered it. My lord, Kushal, I think your lordship has perhaps not noticed. I had on the last occasion pointed out that Kushal was not about the issue of higher pay scale. It was CAT employees and Delhi High Court employees which were at par. So Kushal was inapplicable to them. Kushal, the DOPT circular is not applicable.
We remember your set.
Yes, your lordship may see, I don't need to challenge Kushal. And who am I to challenge Kushal when it is not pertaining to ESIC? Firstly, there are 2 points. Kushal's ratio is different. Kushal,
we have followed that. So your vetting stone, the vetting stone with you would be used on 3 of the employees. So be it. What can we do? Do that.
My lord, it will have a far-reaching consequence if it is 3 employees, 10 employees.
When I am observing in your favor, still you say far-reaching consequences. What
Sorry.
I'm observing in your favor, though I point towards you, but the observation is in your favor against Mr. Datta. Don't see your... All right. We reserve the judgment when we say aloud.
Lord, one correction of my friend, I don't know the number of employees. So, my lord will leave that number for ESIC.
We'll leave that open. We'll see that you will make that exercise on the basis of what you have declared. on the basis of what you have said and then take necessary course correction. Correct?
Grateful, Lord.
All
Grateful.
right.
I'm
Argument said,
grateful.
argument said, we will not dictate it. No. Argument said, judgment reserved.
Oblige.
मेरे पास दे दूंगा इस बार. With all the judgment. Thank you.
Item 16.
इतना ऑफिस में memorandum let us first go through this order.
My time slot is limited, my lord.
Why?
I think lordship will be rising in 3:45. I will try to satisfy my lord within that time.
No, then if it spills over, then the effort will be useless. Then the time would not be well spent.
I'll
Finish it in 10-15 minutes.
10-15 minutes. It will be difficult. I am handling 200 plus persons, my lord. My soldier is a bit heavy. I'll not be able to run that fast, my lord, with 200 plus persons responsibility in my soldier. Perhaps at least little bit of time I'll limit.
A 50-person carriage or a 20 persons carriage, does the driver feel the pinch because of the number? Is the machinery which is important? Is the steering wheel which is important? Is the lubrication of the wheels which is
My lord,
important?
horsepower is also a factor. My lord. Horsepower is also a factor.
Horsepower, not, I mean, the carriage weight has got nothing to do. I mean, that's the laden weight.
That's true. But even then, my lord, I'll take some time, my lord, at least.
Some other day we'll hear you. 3:15 you have a pen.
Four. Lordship is supposed to rise 3:45.
When next?
12.
12.
Let's wait for you. Does this matter? We'll say for final determination.
Yes, my lord.
List this matter for final determination on February?
Fine, my lord. Except Thursday, my lord.
Thursday.
On 20th को बहुत लगाया ना? On 23rd of February.
23rd of
Monday.
Fine. Huh? 23rd. No. 23rd.
बहुत important.
Item 17.
Highly obliged.
I think, Mr. Das, we have said everything in our order, interim order, haven't we? It was only
Lordship.
Mr. Chaudhary who had to ask it. No.
No, my lord.
Oh, he was
That
not.
was absolutely prima facie view. I did not even, my lord, folded a single paper. Lordships raised two very pertinent questions, my lord. I am with your lordships, my lord. I'll try to answer those questions, my lord. Highly obliged.
Yes, plastic products. You are challenging the very.
Validity of the rule 4.2B of the plastic waste management rules 2016, right?
Please come to the rules.
Yes, madam.
Yes.
Lordship, page 25. It's not true. Nine. Cheers.
Yes.
My lord, your lordship will find the rule at page 87 of my writ petition. Annexure B. My lord, since I have challenged the validity of Rule 4,
Read.
Rule 4.2 B, my lord. I'm reading 2. The manufacture, import, stocking, distribution, sale, and use of the following single-use plastic, including polystyrene and expanded polymer commodities, shall be prohibited with effect from 1st July 2022. Now, my lord, I am on B. Plates, cups, glasses. Cutlery such as forks, spoons, knives, straws, trays, wrappings, and packing film around sweet boxes, invitation cards, and cigarette packets, plastics or PVC banners less than 100 micron stirrers. My lord, I am only on plates, cups, and glasses. Only 3 things we are manufacturing these 3 items, my lord. Now, my lord, in view of now I'm taking to your lordship. Now, clause 4, my lord, that is equally important for the purpose of deciding the 2 points in this particular case. First of all, whether it is violative of Article 14 of the Constitution of India. And secondly, on the basis of doctrine of proportionality, whether it is valid one. So, 4, any notification prohibiting the manufacture, import, stocking, distribution, sale, and use of carry bags, plastic sheets, and lights, or cover made of plastic sheets and multi-layered packing and single-use plastics, including polystyrene and expanded polystyrene commodities, issued after this notification shall come into force after the expiry of 10 years from the date of publication. My lord, apart from it, my lord, apart from what has been stated in clause 2B, if any other, regarding any other single plastic, the notification has to be issued, and that would come after 10 years of its expiry. Well, first of all, the notification has to be issued. And secondly, if such notification is issued, then it would come into force after 10 years.
They have to make a part. It's up to you on it. You go. مشكلة.
No input. First of all. Then if you use input. Hmm? Yeah. Proportionality.
Yes,
So this is the second notification which has been issued in respect of
but
the,
just tell me one thing, Mr. Bhatti.
yes,
This plates, cups, glasses, cutlery, etc., and whichever items they have said, if it is of more than 100 micron stirrers, then it's not prohibited.
then it is not, that is only in respect of, my lord, that is only in
Only
respect
with
of
respect to PVC banners,
PVC banner,
not with respect to others.
not others.
Why do you say so?
Why it is so? My lord, may I read it again? Please, cups, glasses, cultures such as for discussions such as taking around sweet boxes, imitation cards, and cigarette cigarette packets, plastics or PVC banners less than 100 micron distance. So the distinction has been made, my lord.
Plastic or PVC. Then. मैंने हम 100 माइक्रोन का केवल वो पीवीसी के लिए ये तो एकदम lock stock
And these are single use.
Yes.
But why should you be permitted to make manufacture single use plastics?
No, my lord, I would
The
come.
reason is this.
Yes,
You want to make a distinction between, from the tenor of your argument, we take it that you want to say that an artificial distinction has been made between carry bags, plastic sheets, cover
Yes.
made of plastic sheets and plates.
Yes.
Cup, plates, fork, knife.
Yes.
So these are something which are also going to be stopped, but after 10 years. You know, the
No,
alternative.
after issuance of the notification and
That
from
after
the
issuing
issue
the
of that notification, and when that notification
a
could be issued,
logic
nobody knows, my lord.
that we have followed. But then
Yes, apart from it, my lord, what I am going to submit, first of all, for that particular purpose, first of all, I am taking to your lordship to certain provisions of the act, my lord. That is,
tell me, is it without any rationale?
yes.
Why?
Why? Because according to their affidavit, they have filed the affidavit.
They have filed an
that-
affidavit.
Yes, two affidavits. First, they filed the affidavit, and this honorable court,
Page
my lord, your lordship will find at page 191.
191.
191. That is the second affidavit. First affidavit they filed, and this honorable court directed them to file a detailed affidavit. Accordingly, the second affidavit was filed.
191 is not the correct paging.
191.
No.
It is.
It's an additional affidavit.
Where is your affidavit? The first affidavit? Or the second affidavit, the detailed affidavit?
Affidavit, my lord.
191, Lordship.
191.
That's not. Page is different. 191 something else.
191.
No. 288. Additional affidavit, Honorable Minister of Environment.
Yes, it's not.
This is the second. 288. Mr. 288.
Oh, the page numbers are not matching, Lordship.
It was earlier 191.
Earlier,
Earlier, my lord,
starts from
it was 28.
First
2 to
affidavit
190.
from page 90.
It is called additional affidavit on behalf of Minister
Yes.
of Environment, isn't it?
Yes.
Extended producer responsibility. High littering potential and low utility. Open up. My lord, the correction of the
One
message.
second, 1 second.
Yes.
Yes,
My lord, I have also filed the affidavit in reply against this affidavit.
what have you said?
Now, my lord, the very important para is 7 of the affidavit.
Of?
First, para 7 of their affidavit. It is at page 193.
Yes,
May I read it?
yes, yes, please.
It is humbly submitted that an expert committee on single-use plastics constituted by the Department of Chemicals and Petrochemicals, Government of India, recommended for phasing out of identified single-use plastics, which had low utility and high adverse environmental impact as early as possible. The following 5 factors of utility were considered by the committee: product safety, essentiality, social impact, economic impact, hygiene. The following 5 factors have been considered for assessing the adverse environmental impact: collectively, recyclability, end of life, solutions, impact of alternative environment, and littering city.
No utility, collectivity. Yes,
My lord, now they have annexed the copy of the committee report in support of their contention. My lord, if your lordship will come to the notification, that is, so far my copy is concerned, my lord, that is not.
ठीक है, बोलिए, it is with us.
My lord, that is at page 40 of the earlier there. And directly, my lord, I am taking to your lordship. To table 2.
Difficulty, Mr. Bhatti, is that who can argue against this? It is like arguing against apple pie and motherhood. Environment.
Yes, my lord. I agree with your lordship 100%.
Very difficult to substitute our opinion.
Yes,
or
I
your
have
opinion.
I have a hard nut to crack. I have a very hard nut to crack. I know it, but even though I am going to satisfy your lordship or convince your lordship that I have a case.
The advantages far outweigh disadvantages.
Yes, my lord, then other plastics have
Your
no, why
business
those,
potential is not our concern. 19(1)(g) is not violated. These restrictions are very reasonable. Suppose they would have come out with these notifications by sitting in the central secretariat, not the experts, but generalists, we could have understood. There's a clear reasoning behind including something in port 2B.
yes, my lord, so far my item is concerned, that is not.
The grounds are three. If we the filtrate of all that has been said by Mr. Chaudhary is three. They have identified these items for their high littering capacity, low utility, and very bad collectability. That's the difficulty. And therefore, these are positive hazards.
I agree with your lordship. There is no doubt.
We have to agree with this, no?
But one thing, my lord, your lordship will come to the table 2 at least.
And mind you, Mr. Bhatti, you are arguing only against this legislation only on the ground of it being excessive, the classification being bad, and number 3, disproportionality, not on the issue of the capacity to legislate, the power to legislate.
Yes.
You don't question that.
Yes,
Naturally.
there
You
is
don't
no
that.
question, man.
So therefore, on these 3 grounds, the opinion of the experts would prevail. No, that's what every judgment says, right from text pharmaceuticals down to everything.
Yes. But even though, my lord, on the basis on the proportionality, my lord, I may be allowed to continue the business. And for this purpose,
We can't. It says it must stop from today, from the date of notice.
let the
We can't, but we find, to our surprise, I had not seen this part of the legislation. Neither did I had the occasion to deal with it. But every day we find those plastic
yes, sir.
Forks and plastic knives everywhere. Everywhere.
It is not
They are not
enforced at all.
implementing it.
Neither
You want us to say that it is not being implemented? Let us convert it into that kind of a petition. We'll ask them.
in Guwahati, my lord, it is littering anywhere, my lord, in spite of the ban. It means it is not enforced properly. And similarly, my lord, I had been to Rajasthan. Day before yesterday, I came. Where it is also so.
That can't be used. Say plastic carry bag. At least collectors can take it. They use it for other purposes. With this, you know, the plates, cups, glasses.
Carry bag is also of the certain microns, my lord. Not below that microns it can be used. That's the restriction, my lord.
Suppose there is a party in a house. 200 persons are the invitees. All of them eat in that plastic plate. It's thrown. Can it ever degrade? I mean, it's what is it? It's not biodegradable. It is nobody collects it. It can't be used.
But so far my items are concerned, my lord, they can be recycled.
Recycling, yes, we can understand. It could be recycled. Collectability, not for use, but collecting it for putting it in compressor, making it into another plastic sheet or something.
My lord, from table 2, I am going to show your lordship that other similar items which have been exempted under this notification, those are have the similar potential of this littering, my lord.
All right, Mr. Bhatti, we have to rise for my brother's bench.
My lord, let
Arguments to continue.
Yes, sir. Day after tomorrow, my lord, if possible.
Oh, yeah, we will finish it and keep it pending. You have challenged the vice.
Yes.
We keep it on 22nd. Arguments to continue, list this matter on 22nd of January. Let's be done with it. Let's see. Your distinction would be very interesting to hear. How do you make that distinction, especially when I say that this is like arguing against apple pie, motherhood.
That's
But the rest of the matters?
Item number 19.
19 is that acquisition of land by
Yes,
NF
yes.
Railways. Some other time. Today we will not.
My lord, can it be, my lord, prior to
Prior to?
5th of February, my lord?
No, that will be too early. We'll keep it in the second week or third week.
My lord, I will be out of session, my lord, up to 15th, my lord. I have some.
After 15.
17 February.
No, March, after 15 March. then.
Whichever date is convenient to him, let us get up and after that you take a convenient date from the gentleman advocate, we'll have it. Subject to the approval of Mr. Mahanta. All right?
Yes.
So 19, 20, who appears?
21, my lord, I have been appointed as a Ramukh Puri to assist my lord, my lord. One thing I find, my lord, that my lord, there was a direction to appoint a Ramukh Puri for the appellant also in jail appeal.
We pass an order.
That has not been done, my lord, and my lord, secondly,
Order shall be passed.
my lord, only one thing I would like to point out, my lord, the judgment part is there, but my lord, after sentence was had, my lord, later on, but that order is not there, my lord.
Second part was it?
Second part, that one. Conviction is there, my lord, the judgment convicting him there, my lord, but
And sentence, what happens? It's not in the paper book.
Second part, the
no, it's
paper
not
book, it is
incorporated in the paper book.
Paper book, laws, only paper book, laws. Otherwise.
There, but not
All right,
incorporated.
we'll have it.
We may be funding the code.
Incorporated, you
We'll
get-
pass an order
Lost,
and
lost.
please give a date.
Your date sometimes in March.
March.
Lordship,
March.
Lordship,
March, we are fixing it on March.
Lordship.
19 March.
Oh, give the, take dictation.
Each time the file, I'll give it to them.
Now, for item number 23 now,
23 and 24.
what is this?
Challenging the virus of the rules in this case. These petitioners have been litigating since 2019. We are the selected candidates. And at the end of the few months back, the department came up saying that the validity of the select list has gone in view of section 20, rule 20 and subclause 3. We said that all throughout we have been making appointments because we are the candidates who have passed out the exams. This is a departmental promotion examination.
So you fall in, you say that you fall in the pool,
Yes.
but that pool should not be made to disintegrate.
Yes, Your
They
Lordship.
were selected. Ultimately, after expiry of 1 year, the list loss is very little. Lord.
Because the unselected candidate.
So you have challenged the rules also.
So now we have challenged the rules because in view of that embargo, Your Lordship. Otherwise, we are selected candidates.
But you still are in service, no?
Yes. Yeah.
There's no urgency.
No, there is only the thing is that the promotion has been stalled and they have already advertised those posts and exams has been conducted. Our post also.
My only urgency is that the recruitment, new promotional recruitment is under the law.
Is there any stay operating?
Yes, Your Lordship.
In the first week of February.
3rd February,
Third will be probably fourth.
4th.
4th of February.
Lordship.
इसका fourth कर दो.
जी, 4th of February.
2 meters, then 17 and 18.